Sir, you're charged with especially aggravated kidnapping. You're also charged with aggravated assault. And you're charged with theft of a firearm worth less than $2,500.
You're talking about stuff that is not relevant.
You will bring the jury.
Hello and welcome to the Court of Public Opinion. I am the Recovery Addict, and boy do I have a case for you today.
Why is the dog chewing on this guy?
I think they have got the wrong guy there.
They got the wrong guy, and the dog was biting him.
He roughing him up quite a bit. There's a lawsuit.
9 out of 10 judges prefer watching the Recovery Addict live stream in their courtroom.
The fireworks are not done.
Now we're getting commentary on the case.
Dati mihi Anglican police service.
That's literally not true.
I didn't ask you to interrupt me.
Is that correct?
Oh, for Trump's sake.
As I just knock my camera completely out of alignment. Good morning, welcome to the Court of Public Opinion. I am the Recovery Addict. I've got to fix this. I broke it somehow. That's going to have to do. Good morning. How's everybody doing today? Happy Friday. The weekend is upon us. Missed you guys last night at the podcast. None of you showed up. I don't know what. I've never had a podcast. No, just kidding. We didn't have the podcast last night. If you missed it, it's because we didn't have one. Busy time of the year. And shout out to Thomas, who's already up and working in Texas as early as it is. Oh, man. We've got a little bit of court hopping today. We've also got some fun stuff to cover. I got a little sidetracked. I'm a tiny bit late today because I was watching a video about a chicken and how they can keep their head locked in one position when they move. Like their head holds still no matter how their body moves. Yeah, that video gets me every time. And we used to raise chickens. I know these things. But still, the video is great. How's your son? He is home. He's home. Now, after driving for 4 hours, counting the time we spent waiting at the airport for him to get his luggage, I drove him and he's like, I don't want to stop at home. I'm going to go visit with some friends first. So I drove for 4 hours, got to the airport, and showed up back at home and had Mrs. Ari. I'm sorry, he's not here. I mean, we got him, but he's hanging out with a buddy. We've got his luggage. Anyway, he had a little get-together last night. It was like a last-chance thing to get together before everyone breaks for the school break, and it was awesome. Chat's not on screen. I'll fix that right now. Let's see. How's my son? My son's doing great. Jennifer Juniper, congratulations. Jennifer J. Juniper. First in chat today, Jennifer. You've been first before, and you'll probably be first again. But today you were first, and we're going to punish you for it. Everything IP-related worldwide is your responsibility. Thank you for doing that for all of us. Congratulations. More experience. She's got enough experience. It does go on your permanent record. All right. I'm excited for today. I'm really excited. We've got some stuff to watch. We've got, we might pop in on some landlord-tenant issues if it gets spicy. Yes, I am growing out my beard. Someone commented, I've got the full beard. I'm hoping to be like the full, compete with St. Nick come Christmas time.
Don't put a diplomatic plate on a hoopty.
Not sure if I can do that, but, we'll give it. I'm putting like Miracle Grow on it. Is that what? I don't know what makes it go faster, but Miracle Grow is what I'm trying, so. All right, we've got some birthdays to celebrate this Friday. Beach Life, Beverly, heavenly birthday. Julia, Kevin, Lena H, Love My Wings, Peyton, and Teresa. Oh, we've got a few of them. All right. That means we need to celebrate these by singing, and let's get started. Let's get it started.
You look
here.
good.
I don't know why I'm excited today. Maybe it's because my son's home and just super excited. He was like super interested in some of the stuff I'm doing, which is always cool. When your kids do that. Anyway, right now he's sleeping because he's very tired. He was up for like 36 hours before his flight. He was worried he was going to miss his flight, so we just stayed up all night. Oh, to be young again. All right, everyone stand up wherever you are. Take a deep breath, shoulders back. Project your voice to the back of the room. Blend your voice with your neighbor and warm up with me. Oh, my goodness. Warm up with me, if you will. La, 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 la. We've got to do that again. Warm up with me, if you will. La 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 la. Oh my goodness. It's going to be one of those days. All right. Beach Life, Beverly, Julia, Kevin, Lena H, Love My Wings, Peyton, and Teresa. Happy birthday to you. Happy birthday to you. Happy birthday to Beach Life, Beverly, Julia, Kevin, Lena, H, Love My Wings, Peyton, and Teresa. Happy birthday to you. 1, 2, 3, 4, 5, 6, 7, 8. Is that a new record? It sure does help that they're alphabetical. Redman, thank you very much for doing that. Appreciate that. Beach Life, Beverly, Julia, Kevin, Lena H, Love My Wings, Peyton, and Teresa. Happy birthday. I realize there are many wonderful days. Today is your special day. And there are a million people you could have celebrated with and a million people you could have been, places you could have been, but you chose to be here with us. The privilege, the pleasure, the honor, the joy is ours. Hopefully we can turn that joy back to you, make your day a little bit more special, or begin to help yourself to free pancakes at Denny's, IHOP, Village Inn, Waffle House, McDonald's, Tammy Dunlop's House, Andy's Grill, Bob Evans, and Cracker Barrel. Best worst birthday start of 2025. It's right up there. It's right up there. Oh, Linda, we heard. It was beautiful. It added something. It did add something. Whether or not you had a birthday the past year, we still love it each and every one. Yes, everyone has had a birthday. Let me tell you some of the things we're covering. We've got a little hearing from yesterday I want to check out. Beverly was my mother-in-law. Happy birthday to her. Melissa, thank you. Happy birthday to Matthew's mom. Yes. Mrs. R.A. is already up and about. She's helping out with the Christmas thing. I think this is the drum solo. Yes, this is it. I think it's a paradiddle. Let me see if I can get some help in here for 1 second. Four waters, and then close my door. All right. My son is awake. The one home from college. All right. Let me do just a little recap. I realize it's a busy time of the year, and not everyone can be here every day. Understandably, I can't either sometimes. I understand that. Jen Pookie says, say it loud, OG, wishing everyone all the best of holidays, lifting up those who struggle during the holidays too. Love to you all. Jen Pookie, congratulations on 29 months. You are an OG. Bug Dugger, did you by chance get the box for me? Not yet. I need to go to the mail post office. I need to send something too. It's sort of weighing on my soul. If you know, you know. All right. Let me say, I forgot what I was saying. It was important. Oh, if you missed yesterday, we had the hearing that wasn't for Sheriff Steins yesterday, and we are trying desperately. Squirrel. Thank you. We're trying desperately to figure out exactly what did happen. We know what should have happened, and I think Anjanette Levy was the one who said the hearing that ended before it began. That was pretty much it. When the mics came on for the pool feed, the judge was dismissing everybody. That's how it went, and he had just sat down. It was so fast. The prosecution is asking for a change of venue. Now this is wild, because if you remember Brian Koberger, the defense was asking for the change of venue. They're like, there's no way we can get a fair trial. Well, now the prosecution is saying there's no way we can get a fair trial in this county. Why? Because the sheriff and it knows everybody in the courtroom, and everyone in the courtroom knows the sheriff. All the judges, probably the good number of all the prosecutors and everything. They're going to have to move it. It's wild to see the prosecution ask for the change of venue. They probably will get it in this case as well. Bond denied, or at least not considered. So there's that. But the change of venue motion, we're looking for paperwork. Kentucky, what is wrong with your court document system? Honestly, you've got like a website. It's like, here, search for our documents. And then there's nothing there. It sends you to nothing. And it's like, oh, we have a courthouse. You should come there. I'm just trying to get some documents online. I got wrapped up in some weird document chase this morning. I'm trying to get something out of Utah as well on Tyler Robinson, and that for some reason is hard to find. And ended up paying Pacer, U.S. government, like a whole bunch of money to add to my Pacer account because we do download some stuff on the federal side occasionally. Before I realized I should have been the Utah one, not the federal one. So nice. If you need some federal documents, let me know. I've charged up my account with Pacer. Added some to Utah as well, and did a couple. Utah charges. Can you imagine if Google, every time you entered something in the Google search bar, it had a little pop-up notice that says this is going to cost you 20 cents. You sure you want to do it? Like, I'm just searching. I'm not going to the website. Yeah, I know. You're just searching. It's going to cost you 20 cents. You want to do it? That's what Utah does with their court document finder fee. Everything costs money. Like, just to Google it on their system costs money. 20 cents just to search. Wasn't what you're looking for? Still cost you 20 cents. It is the weirdest system. But Mountaintop Media has the documents. Okay, that's out of Kentucky. Fly guy, thank you very much, Jordy. Appreciate that. We'll have to look and see what I know. The people that have the documents are usually keeping them close to their chest for some reason. Let's see what else. Anyway, so that covers the Sheriff Stein, Sean Steins. Next hearing, we're not sure when. I don't think there's a new date. He's also getting sued by the family of the judge in a civil suit. That hearing starts, I think there's one on the 7th of January for the civil suit, the wrongful death. So that's going forward. That'll be spicy when it gets figured out where it's going to be. Other things that happened. Rhode Island, or I guess New Hampshire, they found the shooter in the Brown University incident. Self-deleted in the storage unit. But a big sigh of relief for a lot of people as everyone was on edge after he went on his little rampage on campus, and I believe 2 people were killed. I don't know, was the professor shot previously? There was like a separate incident. I don't know if he was killed or if that was before or after, or if he lived or not. It wasn't clear from the article that I read. Crazier Cat, am I considered an MG? NG, new goat. MG, middle goat. Crazier Cat, you are the middle goat. Thank you. Let's see. Tony, good morning to you. Thank you for all your help, Tony. Never a bother, by the way. You're never a bother. Appreciate all your support. The Steins hearing from yesterday got delayed. They didn't have it as what was announced to court. Yeah, nothing was decided. So clearly his bond was not changed. He's not let out on bond, although that could be a thing that happens. And I think Angela Levy, she's the one I watched the feed on. I think early this morning, she was explaining how Kentucky's system for bond is a little different. It's not, they don't look at it as like, this is this charge you're charged with, how serious it is. We're not going to do it because, murder, that's a bad thing. Instead, they look at how strong the case is. Prosecution has, and any possible defenses that you might have to that charge, and the mental aspect of this particular case is a defense to it, and there's a chance he could get let out on a high bond, which will be interesting. All right. But is charging for the docs legal? Isn't that public information? Oh, it's an access fee. You can get around it if, I think in some situations you can like file and request a exemption for, whatever. It's a pain in the butt, and it sure isn't instant, but I just pay for it because I want them now. And they send you sign up for Utah has a program called Exchange. Exchange is what they call it. And you sign up to log in, and you have to, your password and email and address and everything else. And they're like, all right, we will send you a letter in the mail, snail mail, and you'll get it in the next 7 to 10 days as business days. And it will have in the letter a code that you enter to verify that it's actually you. This is like straight out of, why don't you send the Pony Express? Because that's the time period. You're literally sending a snail mail letter for me to do a verification code that you could send to my phone instead. Alternatively, you can put on file a valid credit card and we can charge you to make sure it's valid, and then we'll approve you right now. So yeah, it's a money grab. It's funny. But 7 to 10 days, I'll expect, because I changed my password, I get a new code. But anyway. All right. So any questions on what happened yesterday, let me know. They get my money, and they hold my money. If I don't use it, they just hang on to it for years and years and years. Andrea Burkhart follows someone on Twitter, posts all the court docs. I don't know who it is, but she mentioned them in her stream yesterday. Andrea has been following this one closely. I think she probably will be there. If she isn't, she wasn't. Yes, she's going to be a good one on the Sheriff Steins case for sure. In the Tyler Robinson case out of Utah, which is where we were looking for documents, Utah usually tracks cases by an offense number. Like, here's your ticket ID, and then they keep it that way, and then eventually they'll give a case ID. I can't find Tyler Robinson's case ID anywhere. It's just not there. But we know some hearings are going on, and we're trying to find where the documents are. And I'm tired of paying 20 cents to have the system tell me that Tyler Robinson does not exist in Utah's court system in Utah County, where he has been scheduled and appearing in court. So, all right, we'll get that figured out. But in that case, the thing of interest is that the defense, and you have to realize I'm going to sneeze. Hang on. You can tell my nose is just tickling. I have a mute button just for this. All right. The defense is the same. He has the same person on his defense team that was on Corey Richens' team. And we know what in Corey Richens' team, when Sky got off the case, that when she withdrew, she basically burned all the bridges and filed for everyone to be dismissed, and just sent it was like all shots. She burned all the powder storage. She lit the kegs on fire, just trying to just shake it up, and then she withdrew, all on the same day. So we've got one of the same people from that team. I wonder if she got the idea there. But in Tyler Robinson's case, they have filed with the judge saying, we would like to recuse the prosecutor and the entire office, because one of the prosecutors in the Utah County, which is the county the shooting happened in, prosecutor's office, had a family member who was present at the event when the shooting occurred. And that family member allegedly was texting one of the prosecutors, and the prosecutor shared those texts with other people in the office. So it sounds like they have a legitimate cause for complaint in this one, which what it would do would basically possibly move this out of the county, which is probably going to happen anyway, honestly. They've got to find another county. Utah County is right next to Salt Lake County. They could go south, but it's a little when it comes to heavily populated counties in Utah, you've got like a little bit of population way down south, down in St. George. There's a lot down there, right before you cross the border and heading towards Vegas. And then there's like a big expanse of almost nothing. You've got Cedar City and Kanab and stuff in the middle, and just nothing. I won't say wasteland. It's a beautiful, beautiful country, and I love it. Until you get to the Wasatch Front, where Utah County is sort of like the south end of that, and it's heavily populated. That's where you have like BYU and UVU, where the shooting occurred. A little farther north, you've got Salt Lake County, where the University of Utah is. Park City is Summit County. It's where Corey Richens, just right next to that. And just north of Salt Lake, you've got Davis County, which is heavily populated, suburban area. And then Weber County. And then it sort of gets sparsely populated again, a little batch of people up in Logan as well. So there are some counties to move to that would have plenty of people to draw from. That should be easy to find a jury in. But it's probably going to go to Salt Lake, Davis, Weber, Logan, Summit. One of those counties. I just can't see it going anywhere like down south. That would just be, too far. So there's a chance that one's going to move. I think it will. If it actually goes to trial, we'll see how that works. Oh, okay. Anything else? I have 2 Tyler Robinson. Do I have any? Josh, I was looking for the filing on the motion to recuse. Do you have that one? Do you send it in mod chat? Mountaintop Media is where to check for the docs. I will look and obviously credit Mountaintop Media for the hard work of probably what probably happened. Mountaintop sounds like a Kentucky name for sure. Mountaintop Media. Probably had to go there in person to get these. Do a quick follow here. There are a couple Mountaintop Medias. That one's all sports related. That's not the one. This is the one. Got a call coming in. Oh, it would help if I listened to who it was. Hold, please. Hey, this is RA. Who's on the phone? Oh, call failed. It was overseas. I think possibly Sloth Life. All right. I drove from Salt Lake City from the Grand Canyon. What a beautiful but desolate drive. It is very sparse, especially if you've grown up in a humid area where there's a lot of vegetation, like out east. It's difficult to see very far because there's just trees everywhere. Utah, you can see for miles and miles because there's just sagebrush. You know, you can hide a rabbit behind it, but not a car. And but there's incredible country. All right. Sounds like you should do a collab. Mountaintop Mark Media. Yes, that would be funny. Might have to reach out to them and see what they've got. I'm looking for their posts to see if they've got something on that. Okay. They're on Discord. Hey. I'll have to go to Discord. All right. Thank you, Amber, for that. I'll have to remember my password and log in. Sorry, Discord. When you lose your password or when you don't log in for a little while and have to log in again, and they're like, now you need to remember one of the 12 random passwords we showed on your screen 6 months ago, and not use one that you used before. It's like, seriously? Can you do a better? It's not like I'm trying to recover a lost crypto wallet, right? I'm just trying to log into Discord. Sorry, that's my rant for the day. I'll stop, Amber. I will. Sloth Life OG left a voicemail with case number for Ty. Okay. Amber gives me the link to get right in. Not seeing it. Okay, Amber, Discord is open, but I guess my app can't get there. I click the link, it opens up to my voice call page. Who is Collin Gray? Allie B, we're going to talk about Collin Gray in just a minute. Actually, we're going to listen to yesterday's hearing. It sort of flies under the radar, but it's probably going to get more attention. This is a parent of a school shooter case. But it's not like the Crumblies. The Crumblies were bad. This is worse. Maybe even direct knowledge type things. We'll look into how much he knew and when. Yes, input new password. Next screen. New password can't be the same as previous password. Yeats phone. This is it. This is how RA finds stuff for us. You're seeing the machine in real time. It is. Got up early, just well rested because I went to bed so early, well before 1 o'clock. That's early, right? Went to bed early and just got plenty of rest. All right. 80s, yeah. Heartbroken for Greg and his family. Don't know all the details yet. Obviously, Cletus McFarland, good friend, confirms identity for knowing that Greg and his family were headed out to his place to hang out with him, and they never made it. So that's terrible. Today's my last day of work till next year. Barb, I wish I could say the same. I don't wish. I like being here. But I will be working many days between now and next year. And maybe, Barb, you could join us for those days. What time is the hearing today? Selena, we're going to watch that here in just a minute. I've got it queued up. And we'll do that first. Does that work? So, anything else? I know there's something. There's something I'm missing. I can't find it, wherever it is. Rebecca, also last day of work until after the new year. How was last night with your son? He pretty much slept. I got lost. Okay, I don't get lost often. But we were at RDU, Raleigh, Durham International Airport. And I've been there many, many times. And driving home is pretty easy. You just pretty much drive straight west. Or straight east, sorry. That it makes a difference. Went straight east, and but it was raining, and it was dark. And I don't know, everybody and their dogs were leaving the airport, and it was crazy traffic, like heavy traffic, and then every other car was like some supercharged Camaro who had to be somewhere faster than me. And so everyone's cutting in and out of traffic, and it's like, I'm just trying not to get hit. I don't care how slowly I get home. I just don't want to get hit by somebody. And so I've got the GPS going. It's telling me to turn here, do that. And, of course, I added a stop. That's where I went wrong. I added a stop, and we stopped and got some fast food, which was delicious and nutritious, and it tasted like chicken, which was bad because it was Burger King. But we then tried to get back on the freeway, and somehow it never told me that I took a wrong road. But I'm driving along, like, I do not recognize where I'm at. It never said, make a U-turn. I never got any of that. And it's like, up ahead, take this exit. I took the exit. Next thing you know, I'm like, why are we still an hour and 15 minutes away from home? Like, why is this? The time should go down the longer I drive, right? Maybe there's traffic up ahead. I'm looking at the roads. I'm like, it's raining like crazy. It's dark. There's just taillights for as far as you can see. And I'm like, I do not know where we are. I mean, I can see on the map. My phone is going, GPS is connected. It says I'm headed home and I'll be there an hour and 15 minutes. I just don't know where I am. And I call Mrs. R.A. And this is actually a moment of pride. She's like, hey, what's up? And I'm calling her on her cell phone, her new cell phone. And I say, I'm lost. And she says, I know. I've been following you on Find My Phone. You took the wrong exit. I'm like, you've been watching this whole time, watching where I am, because she was watching my son fly in on the Flight Radar app, and then she watches me drive the whole time, which is cool. I mean, we share our locations. That's what how it's supposed to work. But you watched me took the wrong exit, and you didn't ever think why are you headed to Goldsboro? South Carolina's the wrong way. She never said a thing. She's like, yeah. You could take a left and up here in about 8 miles and go back up towards Wilson, then hang a right. You'd be back on 265. I'm like, you didn't call? You didn't text? You're just like, oh, there he goes. There he goes. He gone. Anyway, I did eventually make it home. But I love that she was tracking me on the phone, using her phone, because that means she's holding her phone. She has it with her, and the odds of her then keeping it with her when at some other time is higher. So anyway, that's what I wanted to tell you about. Now we can watch court. That's what you guys came for. Anyway, So let's get set to do that. This is a hearing. This is a hearing that happened yesterday, and it's only about half an hour or so, but a little over half an hour. Let's see if I can get this pulled up. Do we have sound? We do have sound. Do we have picture? We do have picture. This is Collin Gray. I don't know a ton about this case, and I don't even remember the school this happened at.
All right, we're all present. State of Georgia versus Collin Gray, 24 CR 593. We are here for motions. If I recall, we did not finish a motion from before because there was a witness that wasn't available. Is that right?
Yes, Your Honor, for the Jackson Deno hearing on the statements.
Okay.
We're in
Can you
Georgia,
tell me
right?
what motions we are hearing today?
Can you tell me what motions?
We are going to hear the Jackson Deno on one of the statements on the day of the shooting, and then we're also going to have a witness testify about the statement from the year before that was made to Jackson County Sheriff's Office to Investigator Miller, and then the other part of the motion to suppress from the previous hearing with the search of the phone. That witness was unavailable, and so she is Agent Ward. She did both the interview and then she also got consent. So.
All right. Is that right, Mr. Hobbs?
That is correct, Judge. And on the motion to suppress the search of the phone, we're going to ask if we can prepare a letter brief, though we will make a short argument just so that we know what we're going to be arguing in that letter.
Motion to suppress.
Yeah, not an issue.
Thank you, sir. Otherwise, we agree with what's left.
All right. Go ahead.
You may start now.
State calls Agent Kelsey Ward.
Yeah, this is the premise of this. He's charged with second-degree murder, involuntary manslaughter, cruelty to children for gifting his son a rifle, knowing he had mental issues.
Raise your right hand. You swear to tell the truth, the whole truth, and nothing but the truth, so help you God.
I swear.
Have a seat and introduce yourself for the record.
I am Special Agent Kelsey Ward. That's KELSEYWARD, and I work for the Georgia Bureau of Investigation.
Good morning, Georgia.
And
good morning,
what
Kelsey.
is your role at the GBI?
And Georgia.
I am a special agent, so I investigate crimes that we are requested to work by local agencies.
And what region are you in?
I'm in the GBI Region 11 field office, which is located in Athens, Georgia.
Does that include Barrow County?
It does.
And were you in that same role in September of 2024?
I was.
Did you become involved into an investigation into Collin Gray related to the Appalachia shooting?
I did.
When did you become involved in that investigation?
That morning, not long after the incident occurred, my field office responded to the school where I actively became involved in the investigation.
Did you interview Collin Gray?
I did.
And when did you interview him?
I interviewed him later that morning at his residence in Bethlehem, Georgia.
What was the purpose of that initial interview?
We went there with the intention of just gathering more information about the shooting itself and background on his son, Colt Gray.
Where did you first come in contact with him when you got to the defendant's residence?
I noticed that he was sitting on the bed of a pickup truck outside of the residence, and he was sitting on the tailgate of that truck.
A tailgate
and
interview?
Did you approach him?
I did.
Tell us about that initial interaction with him.
I approached him. I introduced myself to him. I explained that I was a special agent with the GBI and that I wanted to conduct an interview with him, and would he be willing to speak with me. And he asked me if I could provide him with any information about what had happened at that time, and I told him I didn't have very much information to provide.
Did he agree to speak with you?
He did.
And was that initial interaction where he was sitting on the bed of the truck, was that recorded on body-worn camera?
It was.
Okay. Was it recorded on a body-worn camera that you had?
It was not.
Okay. Does the GBI have body cameras?
No, I'm not issued a body camera with the GBI.
Whose camera was it recorded on?
It was a Barrow County Sheriff's Office deputy named Anthony Townsend.
And have you had an opportunity to review that recording of your interaction with Collin Gray on September 4th?
I have.
Is it a fair and accurate recording of that initial interaction with him?
It is.
Have there been any additions or deletions?
There have not.
And at this time, Your Honor, I would like to introduce into evidence State's Exhibit 2, which is a small clip of that initial interaction between Agent Ward and the defendant.
Mr. Hobbs?
No objection, sir.
All right, 2's admitted.
Okay, and we're going to publish that for the court.
Debbie, I love it.
We
It's
need,
a crime scene
All right,
jinky
it's on your
TV.
table. You need the TV.
yes.
for cleaning my glasses. It's perfect. All right, here we're watching the video of the interview. Sitting on the dock of the bay. No, he's sitting on the tailgate for this one. Debbie, thanks for sending that. It was beautiful. And the card as well. You're amazing.
As far as more details than that, I'm not going to be able to tell you. Okay?
Oh, the audio's terrible.
Is this okay for us to interview here? Would you like to sit in my office so that it's more personal? Why don't we do that? I'm more tired of that.
And so
That was it?
in that clip, y'all get up and leave. Where are y'all going?
I asked him if he would feel more comfortable interviewing in my state-issued vehicle, which was on scene, and he said yeah. So we moved to my Tahoe, which was parked in the driveway.
Okay, and where in the Tahoe was everybody seated?
So I sat in the driver's seat. Special Agent Amelia Maddox sat in the second row behind me, directly behind the passenger seat, and then he sat in the front passenger seat.
Hoping the
And
audio
was
gets better here.
your door locked to your vehicle?
It was not.
Was he free to leave at any time?
He was.
Did he have a cell phone with him that he could use if needed?
He did. He had it in his hand for most of the interview.
Was he handcuffed?
He was not.
Was he restrained in any way?
No, ma'am.
And was that interview recorded?
It was.
And how was it recorded?
It was recorded on my digital recorder that I use for all of my interviews.
Have you had an opportunity to review that interview, which is State's Exhibit 1?
I have.
Okay. And again, is it a fair and accurate recording of your interview with the defendant on September 4th?
It is.
Any additions or deletions to it?
No, ma'am.
Your Honor, this time I would like to introduce into evidence State's Exhibit 1 and provide it to the court to review at a later time.
Mr. Hobbs?
No objection, Judge.
All right, State's 1's admitted.
Approximately how long was your interview with the defendant?
It was about an hour and a half long.
And what time did that interview conclude?
At 3 p.m.
How old was the defendant at the time of the interview?
He was 53.
Did he get older
could you
during
read and
it?
write?
He could.
During the course of the interview, did you promise him anything to get him to talk to you?
I did not.
Did you threaten him or coerce him in any way to get him to talk to you?
I did not.
Did you provide him any hope of benefit in getting him to talk to you?
No, ma'am, I did not.
Throughout the interview, did you maintain a conversational tone?
I did.
Did you ever raise your voice?
No, ma'am, I did not.
Did it ever become contentious at all?
No.
In your training and experience
So it
as
was
a
not
law enforcement
coerced,
officer, have you had the
threatened.
occasion to come in contact with individuals under the influence of
Coerced.
alcohol or drugs?
I have.
Did the defendant appear to be under the influence of any alcohol or drugs?
He did not.
Did he appear lucid and able to understand the questions that you were asking him?
Yes, he did.
Was he able to answer those questions?
He was.
To the best of your knowledge, were the defendant's statements given freely and voluntarily?
They were.
That's when you have two
At
vehicles
any
driving the
point,
coffin.
did he
Coerced.
ask to end the interview or leave the car?
He did not.
Coerced is what I
Did he
meant to
ever
say.
ask for food or water?
No.
Did he ever ask to use the bathroom?
No, he did not.
At the end of the interview, was he free to leave?
He was.
Okay, voluntary
And
statement.
Did you, in fact, leave him at his house at the end of the interview?
I did.
How old was he at the
Now-
end of the interview?
In addition to doing that interview, did you also seize his cell phone from
I did.
him? Okay. Before seizing his phone, during the course of the interview with him, did he show you his cell phone?
He did.
What was he showing you on his phone?
A number of different things. So he showed me text messages that he had sent and received from his son, Colt Gray. He also showed me emails that were in reference to obtaining counseling services and communication about counseling for Colt Gray.
And was he
bought him a
actively
pew-pew.
bringing out his phone, showing those to you, and kind of manipulating his phone?
He was. So we would talk about something, and then he would show me the text messages, and then we'd talk about it, and he'd show me the text messages, and it went back and forth that way.
Did you ask to photograph the phone?
I did.
And did he allow you to do that?
He did. He let me take screenshots.
And how did he do that? Was he holding the phone and you taking pictures?
He was holding the phone, and then I used my state-issued cell phone to take pictures of what was on his screen.
Nice. So you lose all the digital evidence.
After the interview was over, did you then ask for consent to seize his phone and to search it?
I did.
Tell us about that.
So when the interview concluded, as we were exiting the vehicle, I made the decision that due to the rapport I had established with him during the interview, that I was going to ask if he would be willing to consent to turning his cell phone over to me. I presented him with a consent to search form, which is a GBI document, and explained what that meant, which was that we would extract the information from his cellular device using a software program and review that information.
Okay. And when you were requesting consent, was your recording device on at that point?
It was not.
When had you turned it off?
I turned my recording device off at 3 o'clock when the interview ended inside of my vehicle.
Is that your general practice?
It is not. Typically, I probably would have recorded, but this was a last-minute decision after I'd already finished that interview.
I didn't get consent on tape.
And I'm going to show you what's been marked as Exhibit 4.
That's important. Is he saying it didn't happen?
Recognize that?
I do.
What do you recognize that as?
This is the waiver of constitutional rights to a search warrant of an electronic or cellular device.
And is it a fair and accurate copy of the waiver that you provided the defendant?
Yes, it is.
Okay. Your Honor, this time I'd like to introduce into evidence Exhibit 4, which is the consent form signed by Collin Gray on September 4th.
Mr. Hobbs?
Just to put on the record, what cell phone was that for?
For his cell phone.
Yes. It was his black and color iPhone 14.
Perfect. No objection, Judge.
All right, Stage 4 is admitted.
When, kind of take us through how you showed him the form. Did you read it to him? Did he read it?
Yes, so I discussed with him that he was going to be signing this if he gave his consent, and that it allowed me to seize and then search the electronic device without a warrant, and that he had the right to refuse to consent to that if he did not want to go along with that. And then I put in here the description of a cell phone, which was, I believe we determined it was an iPhone 14 in a black OtterBox. And then he signed it, printed his name, and then I put the time and date on there so that he would know what time this consent form was filled out. And then I also asked him for his password, which he did provide to me and is written on this form.
And that was the password associated with the phone that he provided you at that time?
Yes, the black iPhone.
Okay. Did he have, in there you mentioned that it told him about his right to revoke consent.
Yes.
Did he have the means to be able to revoke consent?
Yes, so I made sure that since I was taking his electronic device, that he had my phone number so that he could reach out to me at any point to communicate with me that he did not want us searching that phone. And then I do believe he also provided me with his daughter Jenny's phone number at that time so that I had a way to reach him as well, as she would still have her cell phone.
In order to get him to give you his phone and to allow you to search it, did you threaten him?
I did not.
Did you coerce him in any way?
I did not.
Did you offer him any hope of benefit to give you that phone and allow you to search it?
I did not.
Did he voluntarily provide you the phone?
He did.
And did he freely and voluntarily agree for you to search his cell phone?
He did.
At any point during your interview or during your discussion with him about the phone, did he have any questions about consenting to search, or did he express any reservations about giving you the ability to search it?
No, the only thing he asked is that he take some phone numbers off of his phone before I took it, which he did.
At any point, to your knowledge, did he withdraw consent to search his phone?
He did not.
Did he ever call you after you got his phone and ask that, hey, I don't want you to search it?
He did not do that.
And did he ever say that at any point while you were there?
No, ma'am, he did not.
I don't have any further questions at this time.
Okay. All right, Mr. Hobbs, cross.
Yes, sir. Good morning, Special Agent Ward.
Good morning.
My name's Brian Hobbs, and I represent Mr. Gray. If I ask a question that's not artfully stated or is confusing and ambiguous, whatever, just let me know and I'll try and rephrase it.
Yes, sir.
Okay. So you arrived at Mr. Gray's property around 3 o'clock in the afternoon on that day?
No, I arrived at his property around 1:35 p.m.
Okay. Can you describe the scene when you arrived at the property?
There were multiple law enforcement personnel at the scene. There were deputies, and then I also believe there were some federal agents there with the FBI.
Everybody was there.
And then myself and Special Agent Amelia Maddox with the GBI.
Okay. When you say multiple, if you're able to estimate for me, how many law enforcement officers would have been there?
I'm going to say anywhere from 10 to 20.
Okay. And I assume they were all in uniform?
Uniform, not necessarily. So every agency has a different criteria for what you wear to a scene. And since this was a situation where lives were at risk, you responded in whatever you were wearing at the time. Okay. So some of the agencies wouldn't have necessarily been wearing uniform, but they would have been wearing something that signified they were law enforcement.
Something that would have identified them to a normal person that they were law enforcement.
That's correct.
Okay.
My detective PJs.
And did any of these law enforcement agents that were there, were they carrying firearms to your knowledge?
They were.
Okay. Were you carrying a firearm?
I was.
Was Special Agent Maddox carrying a firearm?
I do believe she was. That is typical of us to carry a firearm.
Gotcha. Now, it appears from the video that we saw, and I know that may not be inclusive of everything that happened with your participation, but it appears that, was it you and Special Agent Maddox that approached Mr. Gray when he was sitting in the back of the pickup truck?
It was.
Okay. And was that the first time you had spoken to Mr. Gray that day?
It was.
You asked him if he'd like to talk to you, presumably.
Yes.
And then asked him if he would like to do that someplace more private, which ended up being your Tahoe, it sounds like.
Yes.
Okay. And you and Special Agent Maddox, I don't know if that would be your official uniform, but it did appear you were dressed in something similar to each other.
Yes, so that is typical of what I would wear on a day-to-day basis, either a blue T-shirt that says GBI agent or a blue polo that says GBI agent or something that says GBI agent, and then tactical pants.
Gotcha. And when you took Mr. Gray to the Tahoe, is the Tahoe marked as a GBI vehicle?
We drive unmarked vehicles, but there is a light bar that is obvious on it. You can see the lights in my push bumper on the front of my vehicle, but there's no marking that signifies it's a law enforcement vehicle.
Okay. So at that point, you, Special Agent Maddox, and Mr. Gray got into the Tahoe.
Yes, sir.
During your interview with Mr. Gray, was he asking questions about your investigation, trying to gather information about what was going on with his son?
Very limited, actually. He asked me initially when I walked up, which you can hear on the footage, if there's anything I can tell him about what's going on. And I let him know that this is an evolving investigation and there's not much information I can give him at that time. I did let him know that his son was in law enforcement custody.
And that was at the beginning stages of your conversation with him, is that correct?
That was when I walked up to the truck.
Before even you got to the Tahoe?
Yes, sir.
All right. So you've given us the orientation of where everybody was sitting in the Tahoe, and presumably at that point you still would have had your firearm on, is that correct?
Yes, sir.
As did Special Agent Maddox?
Yes, sir.
And to refresh my memory, I apologize. Mr. Gray was in the back seat or was he in the passenger seat?
He was in the front passenger seat next to me.
Okay. And you stated that at some point he voluntarily offered to show you text messages and emails on his phone. Is that correct?
Yes, we were discussing this, and he said, I'll show you. And he showed me text messages and emails that were on his phone.
And the emails were in regards to what again?
They were different communications with individuals about counseling that was in reference to Cole Gray.
Such as mental health counseling?
I believe so. I don't have them in front of me, but yes, I believe that's what they were.
That's fair.
Yeah.
I guess it was quite a lengthy investigation a while ago. So if you recall, how did that topic come up? Did you ask specifically about that type of information?
I don't remember explicitly if I initiated that, but I believe he actually offered the information about attempting to get services for his son while we were just asking background questions about Cole's mental health.
Okay. And you stated that this interview was about, did you say an hour and a half?
It was about an hour and a half,
okay.
Yes.
And it took place exclusively within the confines of your vehicle?
Yes, inside my vehicle and right on the outside of my vehicle when we got out.
And Special Agent Maddox, was she there the entire time
She
of
was.
the duration of the interview?
Yes.
Okay. And you stated that after the interview had been concluded, you made a decision to see if Mr. Gray would be willing to sign the consent to search his cell phone.
I did.
How soon after if you can recall, or best estimates, how soon after the interview concluded before you made the decision?
Well, the time that he signed the consent form is at 3:06 p.m.
Right.
And I ended my recorder at 3 p.m., so
Okay.
5 to 6 minutes.
So 5 to 6 minutes,
Yes.
literally.
Almost immediately after we got out of the car, I made the decision to ask him if I could take his phone.
Okay. And just to clarify that, was the decision, he had already exited the vehicle at the time you asked him for consent, if you recall?
I do believe he was standing, I think we were all standing on the driver's side of my vehicle because we were just going over some logistics information, and I was getting his ID data, so like his name, his address, his date of birth, that kind of stuff.
Okay, just the basic identifiers.
Correct.
Was Special Agent Maddox there at the time you had that conversation?
I think
Gray?
she was in the general area, but I don't believe she was directly involved in the consent to search.
Right, okay. And it looks like on that consent to search, there is a line where a witness could sign. It doesn't appear anyone signed. Were there any witnesses to that other than yourself?
No, I mean, because nobody was directly listening to us, I didn't want anyone to sign that, witnessing it, that they had seen that, because it was just he and I really speaking.
So it was really just the two of you talking at that point?
Yes, sir.
Okay. And at the time he gave consent, law enforcement was still at the home? Because now it's an hour and a half later.
Yes. I do believe they may have entered the home at that point to execute a search warrant of the residence, but they were still on scene.
So the investigation was still in the
Yes.
stages of happening, for lack of a better way of putting it.
Definitely still evolving.
Okay. And I know you stated earlier that the decision to ask him about signing the consent was kind of made on the spur of the moment. But you did still have your digital recorder, correct?
Yeah, it would have been in the car where I left it with my notebook.
Okay. But you could have gotten your recorder and recorded that if you had thought to do that at the time.
Yeah.
Okay. Can I have 1 second, Judge?
Yes, sir.
Yeah, okay. Yeah, okay. Well, I thank you for being here. That's all the questions I have. Thank you.
Any redirect?
I just have 3 follow-ups.
All right.
You mentioned the search warrant being executed. Prior to you interviewing Mr. Gray, had you been inside that house?
I had not.
Okay. Did you know anything about what was inside the house, or did you discuss that at all with him?
No, I did not.
Okay. Nothing further.
Anything else, Mr. Hobbs?
It's just one brief question about search warrants. Ultimately, a search warrant was obtained to search Mr. Gray's phone. Is that correct?
I do believe so, yes.
But you wouldn't have been the officer that obtained that search warrant, or the agent. I apologize.
I was not.
Okay. Thank you.
All right. Is she free to go?
Yes.
Thank you, ma'am.
You're welcome.
State call Daniel Miller to the stand. And is this on a separate?
This is a completely separate
motion.
day. Yes,
Let
sir.
me ask: did the defense have any witnesses on the motion that the prior witness was for?
No, Your Honor.
Okay.
Thank you.
Could you raise your right hand, please? You swear the testimony you give in the matter now pending before this court will be the truth, the whole truth, nothing but truth, so help you God?
I do.
Have a seat, please. Speaking in the microphone. If you could introduce yourself for the court reporter.
My name is Investigator Dan Miller, Jackson County Sheriff's Office.
Okay. I want to take your attention back to May 21st of 2023. Where were you working at that time?
Jackson County Sheriff's Office.
In what capacity were you working for them?
Excuse me. I was an investigator.
Okay. And on that date, May 21st, 2023, did you embark on an investigation of something?
I did. We'd received, you want me to go?
Sure.
Okay. My supervisor received a tip from the FBI related to a threat, and we went to an address that was given to us by the FBI, where we discovered that the subject of the threat, I guess you could call it the suspect, was no longer living there and had moved out, I don't know, several months prior. And then the deputy that was with me, the road deputy, had some knowledge that of where he might live, so we went to that address and where we encountered Mr. Gray.
Okay. And this deputy that was with you, who was that?
Deputy Justin Elliott.
Okay. And it was just the two of you?
Yes.
Okay. So then you go to a new address?
Yes.
And did you speak to Mr. Gray?
Yes.
Tell me about that, how that happened.
I knocked on the door, and he came to the front door, and I informed him why we were there and the purpose of our visit.
Okay. And did you identify yourself as law enforcement?
I did.
How were you dressed?
I was wearing what you call an outer carrier, a bulletproof vest, quote unquote, and it had sheriff written in, I believe it was yellow letters on the top, and I was wearing my badge and my gun. I had a hat on.
Okay. Was Deputy Elliott with you at this point?
He was.
Okay. And was he dressed similarly?
A little bit different. He was wearing a road deputy's uniform. I don't know what class specifically it is. Is a button-up shirt with outer vest carrier type thing.
But did it identify him also with Jackson County Sheriff's Office?
It did, yes.
Okay. And what was your tone when you were speaking with him? Was it aggressive, authoritative, or conversational?
I would call it conversational.
Okay. And did he agree to speak with you?
He did.
Okay. And was he free to leave at any time?
Yes.
Okay. And was he handcuffed in any way?
No.
Was he restrained in any way prior to the conclusion of the interview?
No.
Did he agree to speak with you?
He does.
Was this interview recorded?
It was.
And how was it recorded?
Body cam, and I used my county issued cell phone to record conversation. That was a regular practice.
Did the Deputy Elliott also have a body cam?
He did. It was his body cam. I wasn't issued one at the time.
And have you reviewed what's marked as State Exhibits 3A and 3B?
Yes.
Before your testimony today?
Yes.
And what was that?
It was the body cam video of our interview, and I think that was it. What was it? There was two separate videos. Mm-hmm. It was the initial conversation, and then a follow-up conversation, but on the same day at the same place.
Okay. And are they a fair and accurate recording of the interview with the defendant?
They are.
Huh?
Yes.
Okay. And were they material additions or deletions to it?
No.
Your Honor, this time I tender State Exhibits number 3A and 3B.
Hobbs?
No objection, Judge Tyler.
All right.
Just for the record, Your Honor, it's one continuous. It's just broken up into two parts when it was recorded.
Okay.
So one is
We're gonna play them both?
15 minutes and the other is 4 minutes. So it's
Okay.
2 minutes.
Roll tape.
3A and 3B are admitted.
During the course of the interview with the defendant, did you promise him anything in return for making a statement?
No.
Did you provide him with any hope of benefit if he provided you with a statement?
No.
Did you coerce the defendant into making a statement by way of threat or force?
No.
Did you maintain a conversational tone throughout the interview?
Yes.
Did you raise your voice with him during the interview?
No.
In your training experience as a law enforcement officer, have you had the occasion to come into contact with individuals under the influence of drugs and alcohol?
I have.
And did the defendant appear to be under the influence of any alcohol or drugs?
Not to my recollection.
Okay. Did he appear lucid and able to understand the questions you asked of him?
Yes.
Was he able to answer those questions?
Yes.
To the best of your knowledge, were the defendant's statements given freely and voluntarily?
Yes.
At any point, did he ask to end the interview?
Not to my recollection.
Okay. And at the end of the interview, was he free to leave?
Yes.
Did you leave him at his house after the interview concluded?
I did.
Okay. Just a second, please.
Very thorough questioning to make sure this.
Good morning.
Is it Deputy Miller or is there a?
Danny Miller.
Just call me Danny.
Not a stickler with
Titles.
circumstances.
Gotcha. Well, I'll stick with Deputy just for decorum.
That's fine.
So I represent Mr. Gray. If I ask a question that doesn't make any sense, please let me know and I'll try and rephrase it.
Fair enough.
All right.
This evidence is going to do him in if it comes in.
You work for Barrow County Sheriff's Department?
I work for Jackson County.
Thank you. Jackson County.
Yes.
And how long have you been with Jackson County?
The county for 18 years. The sheriff's office, 17 of that.
Okay. And where were you at before the sheriff's?
United States Marine Corps.
Okay. And how long were you in the Marine Corps for?
4 years.
And did you have any experience in the Marine Corps as that you would suggest or that you would believe would be the equivalent of a law enforcement officer?
I did.
And what kind of experience was that?
I did it was about 9 months as a military police officer.
Okay. And when you received, you said you received a tip.
Mm-hmm.
Is that right, from the FBI?
Yes.
Okay.
Well, my supervisor received the tip.
Okay. Perfect.
I'll send it to me.
So your supervisor received a tip, sent it to you.
Mm-hmm.
Why was it sent to you? Was it because of a specific job or a specific role you had in the agency?
I was the on-call investigator for that. We do week-long durations for on-call duties. That was my particular week.
Okay. And how would you, if you could, describe what kind of tip it was?
Can you clarify that? I'm not.
Yes. Thank you for asking. What was the tip was in reference to what? What were you being asked to investigate?
It was in reference to a school shooting.
Okay. And this is, just to make sure we're on the date, not confusing, do you recall approximately when this was, what date it was?
I'm not sure I understand what you're.
Sure. What day did you
I don't remember the specific date.
Remember the year?
This was close. There's for God, thank you.
Gosh, I'm going to have to go back in my memory banks. 23?
Okay.
Or no, actually, it would have had to been. Yeah, it was May of 23, wasn't it? I'm
not sure.
I really can't recall, honestly.
I'm not going to hold you to it, but it was okay. And so you went out and spoke to Mr. Gray that day,
yes,
in reference to this tip. Is that correct?
That is correct.
Okay. And
cell phone.
Did you
press his cell phone?
Did you have any special training? It sounds like you were the on-call investigator that week.
Correct.
Was there any special training you had that made you better suited to handle this type of case, or was it just completely because you were the investigator?
Completely because I was on call.
Okay, gotcha.
I do remember it was a Sunday, so that would excuse me, that would.
Thank you, Izzy. Appreciate it.
Anything that would happen on a Sunday that required a follow-up investigation would be assigned to whoever was on call.
Okay. And after that particular interaction with Mr. Gray on that day, did you ever have any other interaction with Mr. Gray? Phone calls, anything like that?
Yes.
Was there? When was the follow-up phone call? Like the next, not the date, but the next day, 2 days later?
I think it was either Monday or Tuesday of that same week.
Okay. So within a week of the initial meeting.
Mm-hmm.
Okay. Can I have 1 second, Judge? I think I'm almost done, Deputy.
Defense trying to say that this evidence is really harmful towards my client is not enough to suppress it. They need to have legal cause to suppress this evidence because it sounds like it was collected legally.
So the tip was in reference to Colt Gray, is that correct?
I believe it was, yes.
Who would have been a juvenile at the time?
Correct.
Do you have any special training for dealing with juvenile offenders?
Not particularly, no.
Just more of a generalized?
Yes.
Okay, perfect. Thank you, sir.
Is there any redirect?
Just briefly, did you write a report at the time to grain this with this incident?
I did.
And would the date be reflected in that report?
It would.
No further questions.
All right, may he be excused?
It would be 2024 because the shooting happened in September of 2024. Cindy, enjoy the moment. Thanks for gifting 5 memberships. There's the father of Colt Gray. This is Collin in stripes
We have
there.
additional witnesses.
Just argument?
Any witnesses from the defense?
No, sir.
All right.
We're almost done with this one.
Any additional witnesses for any other motion that we need to address?
No, Your Honor.
Anything from the defense?
No, Your Honor.
All right. So I understand y'all want to submit.
Look at that chair.
You want to do some limited oral argument, but you want to submit letter briefs?
So I don't even want to do any oral argument, but the holidays are coming up, so I want to give them a head start on what I'm going to be arguing, so they're not scrambling it. So I'd like to turn a letter brief in by Tuesday of next week.
Okay.
I don't want it to drag on farther than that. We're going to argue about whether or not the consent given was consensual. And as to the search warrant that Your Honor will get a copy of, we're simply going to argue whether or not it was particular enough in the search warrant not to be a general warrant. So just to give the state a bit of a head start on what we're going to be arguing so that they're not scrambling over the holidays.
And has that warrant already been admitted?
You hit the search warrant.
Are you talking about the house search warrant
Or the cell phone?
The cell phone.
That chair is massive. The headrest is like a full 4 feet wide. It's a throne.
Okay. So it turns out the search warrant we have on the black iPhone is a different black iPhone.
Okay.
So I don't think we just need to argue the first part, which is whether or not consent was valid. Because the search warrant was not obtained for Mr. Gray's black cell phone. It was a different black cell phone.
Okay.
So that takes care of that issue, makes it even easier.
Very good.
Thank you, Judge.
Technicalities can be a big
Anything
issue.
else that we need to address today by way of motions? I don't know that we have another motions day scheduled between now and early February.
Are we going to have argument on the Jackson Deno hearing or?
Judge, so the Jackson Deno hearing in regards to Deputy Miller, we don't have argument on that. I think the state wanted to just kind of cross all the T's and dot all the I's.
Okay.
We weren't really challenging that statement, but the state's right. It's better to have that motion and deal with it.
Ms. Brooks?
No objection to that. But as far as Agent Ward's, are we having argument on that? Or are you gonna
No, I'll just do a quick letter briefing and
Okay.
get that to the court by Tuesday.
The state has not filed any specific motions related to evidence in this case. We filed some notices, like a notice of business records, a notice regarding our investigator remaining in the courtroom. So, and the only motion that we filed that I don't believe they're objecting to is just what can be viewed by like recording devices. There's certain like crime scene photos and things of that nature that we're requesting not be allowed to be
shown
put
to the
on
public.
any sort of recording device. But I don't think the defense is objecting to that. So I don't believe there's any motions that
graphic.
we have that are pending.
Okay.
I would agree with that. We did get a notice of business records. We'll review that. There's quite a few.
Okay.
I don't foresee there being any issue, but we may follow up with the custodians just to make sure everything is the way we think it should be. And we would certainly let the state know if there were any issues. I did see the motion about the investigator yesterday. We don't have an objection at this point. I'll chat with Ms. Brooks just in regards to if that person is testifying or you're planning on that person testifying. But I'm sure that they will tell that person not to discuss the case or testimony with any other witnesses. So at this point, there's no objection to that. And as the photographs, we'll sit down with the state. We'll go over all that, but I don't have an objection.
Okay. How long would the state like to respond to the letter brief that I'll be getting by Tuesday.
Since that would include Christmas, I believe, so you're saying Tuesday of next week would be the 23rd?
I'll get it to you Monday.
Okay.
Yeah.
So
it should be pretty quick.
I don't think it will take very long. I would like 2 weeks just because I'm not sure. I think there'll be several holidays in there, but we may get it to you before the 2 weeks. I'll just like 2 weeks, which would be January 5th. End of business on January 5th.
Right.
Any issue with that?
None.
All right. So the state's going to respond no later than January 5th. All right. Now, I know with the scheduling order, the state's supposed to have submitted a list of witnesses to the defense. Has that been done?
Yes, Your Honor.
Yes, Your Honor, that was done on December 12th.
Okay.
Yes, sir.
All right. So we're on track for, I think it's February 9th. I know, Mr. Berry, you still have that trial in Cherokee County?
I do, Judge. That we had motions on that about a week and a half ago, 2 weeks ago. So we're still on track for that. We hope that we will be through by the 9th. We do have some witnesses in that case, so it's going to take us a minute.
Okay. I'm sure Mr. Hobbs will be ready to go.
It's going to take us a minute.
I don't know about that.
Do my best, Judge.
We'll get through as quickly as we can.
All right.
But one other issue, Judge,
Yes,
I don't know when we want to sit down and talk about the voir dire process and how we're going to kind of go through the jurors as to their knowledge of this case.
We've seen that defense attorney before, huh?
I don't know whether you want to try to schedule another
Where'd
time
we see him
that we
before?
can sit down and do that.
Yeah, I'm happy to do that, and I do have a couple little blocks carved out between now and then just for anything that we need to address. If y'all want any sort of brief meeting today, I'm happy to do that, if that works for you.
Great. I just think it would move things along a little quicker if we knew exactly which way we wanted to
Sure.
deal with that. So.
All right, anything else?
Nothing from the state, Your Honor.
Okay, thank you very much. Y'all have a good Christmas.
Thank you, Judge.
You too.
Bailiff says inmate out. No weapons. No weapons. All right. So that was just a quick hearing in this one. This case is obviously any case that involves a shooting at a school is tragic. And what's terrible is when there are signs to show that it was avoidable. Like people knew or should have known and should have taken steps. This one has a lot of that in it. Obviously, the dad. Hey, bud. Obviously, the dad gifting the son a firearm, a sporting rifle, an AR style rifle. I think was it a Mossberg or let's see what kind it was. It was Sig Sauer. It was a Sig Sauer, but so it's not actually an AR-15. It's just a sporting rifle. Sporting rifles, for those that are not familiar, they're the typically black military-looking rifles that are generally semi-automatic. You can get them in a range of calibers. They're probably one of the most popular and commonly owned rifles in the United States, with estimates around 25 million people owning at least one here in the United States. There's a lot. And it's extremely common. It doesn't make it right to give one to a child who has mental health issues. But that's going to be the case. That's why he's being prosecuted, because the prosecution says that he was aware that there were some mental health issues and he gifted him the gun. Now, guess who else was aware? The police. I believe the FBI had received a tip about the possibility of the son, Colt, doing a shooting. The son had a shrine dedicated to other shooters. There were mental health problems. There were indicators there. But it still happens. 2 students and 2 teachers were killed. 9 others were injured in that school shooting. And so the dad is being prosecuted, as has, since the Crumblies. That was the first one, I believe. There might have been one before. But parents are starting to be charged more and more when their child, who they have custody over, commits a crime like this. So anyway, so that's coming up next year. We will we'll keep an eye on that. We have some documents to read. Thank you very much for all those who have helped. I've got a million emails and texts and some files sent to me and links and everything. So we've been able to find some documents. If you guys don't mind, I'd like to do a little bit of light reading today, going back to the Tyler Robinson case, which is interesting in what the state, what the defense is trying to do to the prosecution. Specifically, let me pull this up. Boom. Right here. You guys see this? Story hour. Yeah, it is 48 pages long. I'm not sure if we're going to read all 48 pages, but I want to get the gist of this motion. Motion to disqualify Utah County District Attorney's Office. Okay, these are the prosecutors. We're literally asking to kick out all the prosecutors on this one. And we're going to see why. This is redacted. This is 14 pages, but there's more here. I think we'll read the 14. Defendant Tyler James Robinson, by and through undersigned counsel. And for the record, this is the accused shooter in the Charlie Kirk killing. And we saw him briefly when he made his appearance in court in Utah County here a little bit ago, a couple days ago. By and through undersigned counsel, hereby moves the court to disqualify the Utah County Attorney Office due to conflict of interest. It is anticipated the court will hear this issue during the previously scheduled hearing on January 16th. So that's going to be a fun one to listen to if the court answers and decides at that time if they're conflicted or not. We'll see. The requested relief, Mr. Robinson seeks an order of this court finding that blank, representing the state of Utah for the, I think it's that Utah County, it might have names in there, representing the state of Utah for Utah County Attorney's Office, UCAO, in this capital prosecution, which is a death penalty case, has concurrent conflict of interest based on personal connections to a direct witness / victim to the events of the issue in this case. Further, Mr. Robinson seeks findings from this court that, 1, upon learning of the conflict, the UCAO did not employ any screening protocol, and 2, information pertaining to the personal involvement of Mr. Blank was shared amongst the assigned prosecutorial team. They texted it around, including the county attorney. Based upon these findings and the interest of a proceeding, Mr. Robinson's federal and state of protecting Mr. Robinson's federal and state rights due to due process, Mr. Robinson requests that this court order from the UCAO is disqualified from representing the state in this matter. Here are the relevant facts. On September 10th, 2025, Charlie Kirk, the leader of Turning Point USA, appeared on Utah Valley University campus in Orem, Utah, to engage in a prearranged presentation to students and other observers or participants. At approximately 12:23 p.m., Mr. Kirk was shot and killed. It has been estimated that approximately 3,000 students and other observers and participants were present at the time of the shooting. Of course, the scene was chaotic and for many in attendance, life-changing. One witness described hearing the shot, seeing Mr. Kirk, and observed that the crowd all collectively dropped to the ground. After a few moments, the crowd collectively got up in unison and started to panic and run. As he and his friends reached their vehicle to leave, they were all hysterical. Another witness, who was 40 to 50 feet from the Turning Point booth, described seeing the shooting and her cousin getting in front of her. The witness got down on the ground, trying to make herself as small as possible. She thought more shots were coming in, it was going to be a mass shooting. She and her cousin sprinted to the nearest building, where she grabbed the nearest trash can and threw up. She described it as traumatic, and she can't stop replaying the event in her mind. Another witness offered, the atmosphere was a pure panic, and I was scared for my life. They're giving this information because the connection the county has to this case is somebody who had an experience like this. And we're going to find out through here that contact, that person, was basically live tweeting or live messaging somebody on the county attorney's office as this was going on. So they were very closely connected in almost real time. Another witness stated right away everyone was on the ground trying to protect themselves from the possibility of more shots. I remember thinking I could not get low enough, and I was instantly scared. I struggled to text my mom that I was safe with shaking hands. Yet another witness shared, we were in shock in the crowd because there was so much blood. I was pulled to the ground and started praying. I thought I was about to die. I was on the ground wondering if the bullet was going to hit my back. I was so terrified that they wouldn't find the shooter and he'd start aiming at us. Even those who were present on campus but who did not see the shooting themselves were impacted and significantly traumatized. Students were locked down in classrooms, experienced panic attacks, and experienced a traumatic aftermath comparable to those for direct observers. And they have TikTok screenshots for that. On September 16, 2025, Mr. Robinson was charged in a 7-count information with aggravated murder. The aggravating circumstance for this offense is that the defendant knowingly created a great risk of death to another individual other than Charlie Kirk and the defendant. The state has not yet identified the other individual supporting the aggravating circumstance. It could be a lot of people that were nearby. We'll see if they identify that or if they keep it quite vague. I think they have to identify somebody. Also on September 16th, Utah County Attorney Jeffrey Gray gave an hour-long press conference explaining the state's intention to seek the death penalty against Mr. Robinson. Blank and other members of the prosecution team were present at that press conference. During the press conference, Mr. Gray conveyed, I also want to express my concern for everyone who was at Charlie's Turning Point USA event at Utah Valley University and all who have been impacted by this tragedy. Unfortunately, one of the students in attendance at the Charlie Kirk presentation on September 10th was the blank, that's relation, of Mr. Blank. At the time of the shooting, Mr. Blank was with the Utah County Attorney Jeffrey Gray at a presentation in Davis County. Mr. Blank began receiving text messages from his blank, child, daughter, cousin, niece, nephew, I don't know, insert relationship there, and shared those with Mr. Gray in real time. Mr. Blank also called another attorney at the Utah County UCAO, and almost immediately told him about the shooting and shared his Blank's texts with him. Mr. Blank had described the text message exchange as follows. Charlie Kirk was shot at 12:23 p.m. and at 12:25 p.m. Blank texted my family text group. Someone got shot. And almost immediately afterward, Blank texted the same group. I'm okay. Everyone's going inside. At 12:26 p.m., Blank texted the same group. Charlie got shot. At 12:30 p.m., texted the same group. People say he was shot in the neck and his head like tilted or something. At 12:33 p.m., I texted my Blank, did you hear a gunshot or what sounded like a gunshot? Blank responded to me at 12:38 p.m. I for sure heard it. Everyone started screaming and running. A few people said they saw the shot hit his neck. Not sure. Mr. Blank believes that he discussed his Blank's presence at the event with others in the office at the time. He also discussed the exchange. So in this, Mr. Blank, this is somebody in the office, believes that he's like, best of my recollection, I talked this over with everybody in the office. He also discussed the exchange of the potential conflict issue with the entire prosecution team prior to disclosure to the defense. Mr. Blank holds a supervisory role at UCAO, and as the blank under Mr. Gray. There's the Utah County press release that shows his position. At the request of Mr. Blank, he and the UCAO investigator went to UVU campus to determine the exact distance his relative was from Mr. Kirk. His relative was approximately 85 feet to the northeast of where Mr. Kirk was seated when he was shot. His relative's backpack was left in the amphitheater as he or she, I think it's a he, fled the scene because there aren't enough letters for she in there. So I think it's giving it away that way. Mr. Blank disclosed this information by email to Mr. Robinson's counsel on October 1st, 2025. Defense counsel Mr. Blank and other prosecution team member Christopher Ballard spoke about this issue on October 9th, 2025, and additional information concerning communications within the UCAO was provided at that time. Mr. Blank has stated to Mr. Robinson's counsel that his Blank will not be a witness for the state and that he does not believe that his circumstance presents a conflict precluding him from participating in the prosecution of Mr. Robinson. Mr. Blank provided the same information to the State Bureau of Investigations, so there are lots of blanks in here. Mr. Blank's conflict of interest in the argument requires his disqualification as his continued participation in the prosecution would violate Mr. Robinson's state and federal due process rights. Mr. Blank's familiar relationship with the witness presents the reason why they're blanking out his name as somebody who works in the office is because by definition, his relationship to the victim would identify the victim. Does that make sense? So big blank and mini blank. Yes, Camilla, we've got mini blanks. We are reading a long motion. Let me pin this. Red pen, thank you. There it is. Mr. Blank's familial relationship with a witness presents a concurrent conflict of interest and disqualifies him from participating in the prosecution of this case. Mr. Robinson's due process rights require Mr. Blank's removal from the prosecution of this case. And then they go on. Under Utah Code 1768-501, attorneys who serve as a public prosecutor shall conduct on behalf of the state all prosecutions for a public offense committed within a county or prosecution district. Attorneys serving as public prosecutors are ethically bound by statute according to the following. An attorney exercising public prosecutor duties under this chapter is a lawyer representing an organization as a client under the rules of professional conduct, represents the state as an organizational client, is considered the representative of the state, and is empowered to make commitments for and decisions on behalf of the state. Like all Utah lawyers, those serving in public employees are also subject to rules of professional conduct, which outlines when a lawyer shall not represent a client because of concurrent conflict of interest. So they're saying the law requires him to recuse himself and be removed. A prosecutor has the responsibility of a minister of justice, not simply that of an advocate. This responsibility carries with it specific obligations to see that the defendant is accorded procedural justice and that guilt is decided upon the basis of sufficient evidence. Utah, also there's a citation. To this end, it is clear that a prosecutor should be disqualified on a timely motion when he has personal conflict interest in the case. Relevant here. What they're basically saying is the state says, based on the charge, that the shooter, the alleged shooter, or that Tyler allegedly put someone else at risk by committing this act, by doing the shooting. That someone else could be hypothetically the person who is related to this prosecutor. That's a conflict of interest. That's too close, right? And they might be right. They might be right on this one. I thought this was going to be federal. There are state charges as well. I'm sure federal will go after him for things as well. But it is a conflict of interest. As you know, I'm not saying right or wrong, or obviously we're not arguing politics on this at all. But the conflict of interest is a problem. And it needs to be addressed because even if one person can say, "Look, I'm going to be just straight down the middle. It's not going to sway me one side or the other. I can be fair." There might be an apparent conflict of interest that how it looks matters. Perception matters to the public, and it matters for due process as well. Because if the perception is not good, that's got appeal written all over it, and you don't want to try a case like this twice. Let's see, relevant here, a concurrent conflict exists if there's a significant risk that the representation of one or more clients will be materially limited by the lawyer's responsibilities to another client, a former client, or a third person, or by personal interest of the lawyer. Utah courts have found that such a conflict exists when counsel may make choices advancing other interests to the detriment of his client. So if he makes a decision that would favorably help out his relative, or would improve their situation or standing or something, or seek for something for them, that's conflict of interest. Public officers prosecuting defendants while laboring under personal conflict endangers a defendant's right to due process. As stated by the United States Supreme Court, injecting a personal interest, financial or otherwise, into the enforcement process may bring irrelevant or impermissible factors into the prosecutorial decision, and in some contexts raise serious constitutional questions. Further, a prosecutor violates the requirement of fundamental fairness assured by the Due Process Clause on the 14th Amendment by attempting to serve two masters. That's, I think, a biblical reference. No man can serve two masters. You got one boss. That's it. In this case, the personal relationship between Mr. Blank and his blank, a potential witness, and victim raises serious concerns about past and future prosecutorial decision-making in the case. Mr. Blank cannot serve two masters and should not be permitted to do so. Mr. Blank's integrity is not the question, and his opinion is that there is no conflict is not dispositive. Rather, his blank's experience raises an objective question as to whether or not the circumstance presents a significant risk that Mr. Blank's personal family interests may materially limit his ability to represent the state of Utah in these proceedings in the manner that is ethically required. Okay, we can do a little bit of deductive reasoning here. Based on the shortness of some of the redactions, we can, I think, safely assume that it is a he that we're dealing with. It's a relative, and the context of this right here shows the position. His cousins, nephews, it's going to be somebody who's younger than him, okay, because that's why we're hiding their identity. So I'm thinking it's a nephew or a cousin. That's what we've got here. Okay. May limit his ability to represent the state of Utah in these proceedings in the manner that is ethically required. The prosecutor is not disinterested if he has or is under the influence of others who have an axe to grind against the defendant. In assessing the irreconcilable conflict that exists here, the court should consider that the production of discovery in this case has only recently begun, and there is no way to say with absolute certainty that Mr. Blank's nephew, cousin, whatever, will not be a witness in this case. The defense is not in a position to make this assessment and should not be required to do so. Similarly, expecting Mr. Blank to separate his role as a uncle with or as a blank with a wholly natural instinct to protect and shield his cousin, nephew, whatever, from past and future harm from this role in the prosecution of the individual alleged to have caused harm to many, including his blank, is not practical and defies common human experience. As described by witnesses on campus at the time of the shooting, the event and the aftermath were harrowing, even for those that did not see the shooting as it happened. Mr. Blank and his blank are not immune to this trauma. There must have been fear, anxiety, anger, and a host of other emotions as the events unfolded. That day and throughout the investigation, culminating in the arrest of Mr. Robinson. These feelings and impressions do not simply resolve because a criminal case has been filed. There is no way to predict at this time what directions this case may take, what critical prosecutorial decisions will be required, and how they may be impacted by the experience Mr. Blank had with his blank, both in real time and after the initial crisis. These influences may be subtle. For example, Mr. Blank may be less inclined to believe a witness whose observations are not consistent with those of his blank, or he may make a specific strategic decisions to avoid his blank having to testify, even if that may not be the best interest of the state's case. Mr. Blank is empowered by the Utah State Legislature to make commitments for and decisions on behalf of the state. The wielding of some of the awesome powers of the government against the defendant must be beyond reproach to comport with due process protections. The risk that Mr. Blank's personal involvement may limit his ability to fulfill his obligation to the state of Utah must also be assessed within the context of the grave consequences being sought by the state, the death penalty. Less than 1 week after Mr. Blank's communications with his blank, while blank was at the Turning Point event where were provided the county attorney and his team, including Mr. Blank, filed notice of the state's intent to seek the death penalty against Mr. Robinson. Such notice is not required to be filed until 60 days after arraignment, which occurs after the preliminary hearing. And yet it was filed concurrently with the charging information. This was very early in the case, historically, to have the state, the county come out and say, we're going for the death penalty. It was like right at the same time we got the charging information. Normally it's 2 months later. The rush to seek death in this case evidences strong emotional reactions by Mr. Blank, the county attorney, and the entire prosecution. I almost said prostitution. Prosecution team. That's a different case altogether. I'm sorry. That was a little bit of a slip. All of whom were informed of his and his blank's personal experiences. The risk here is substantial. Mr. Blank has a concurrent conflict of interest and must be disqualified. Mr. Blank's conflict must be imputed to the entire prosecution office, and the UCAO should be disqualified. Now, I did say it. I did. When disqualification is appropriate, this is, by the way, this does not, it's a different show. Add that to the grievances. This is not saying that that Tyler should not be prosecuted. That's not what this does. It separates that and says we need to have a special prosecutor brought in, or it needs to be prosecuted from outside, which is basically the same thing. We just can't have this team that was so closely involved and has this close of a connection to victims in the case or potential witnesses in the case. They can't be the ones making the call and doing this. So this doesn't stop the case from going forward if this is granted, but it does change who the players are. When disqualification is appropriate, it's usually sufficient to disqualify the particular attorney with the conflict rather than the entire office. This is true. It's rare to have an entire office thrown out. However, whether a prosecutor's office should be permitted to remain on the case despite an individual prosecutor's personal conflict is dependent on the mechanisms utilized to cordon off the potential conflict to prevent the conflict tainting the rest of the office. Apparently, the taint did the tainting thing. In the matter of the State v. McClellan, the Utah Supreme Court found that Utah County Attorney's Office should have been disqualified. So this is great. The case they're citing is one where the Supreme Court found that the current office they're talking about, the whole office, should have been disqualified from the defendant's prosecution. This is a different case. The conflict in McClellan arose from the defendant's former counsel joining the county attorney's office. Oh, that's terrible. He switched teams, creating a presumption of shared confidences between former defense counsel and the county's attorney's office. That is terrible. That's worse. That's you hire a legal defense lawyer to represent you. Your lawyer's like, I've got to withdraw. I've just accepted a job offer with the prosecution on this case. That's bad. That's like lay bad. Okay, that's not even the appearance. That is just, it's terrible. And the fact that they went through with it. Okay. Finding there was no evidence of any attempt to screen the attorney from the case, the district court was under an obligation to disqualify the entire Utah County Attorney's Office. Wow. Also in the case of State v. Balfour, the Utah Court of Appeals found that where the district attorney with the potential conflict voluntarily recused herself to avoid even an appearance of impropriety, the state rebutted the presumption of prejudice stemming from the pre-existing political relationship between the defendant and the district attorney. 2008, Utah app, oh, that's the citation. The conflicted attorney also transferred supervisory authority to another in the office, effectively screening herself from the case. There is no Utah case factually analogous. Did I say that right? Analogous to the circumstances here. The blank being the blank of a witness to a homicide at a crowded event whose traumatic experiences were conveyed to the prosecution team in real time. However, the same core principles espoused by McClellan should apply. Where blank has a personal conflict of interest, prejudice to Mr. Robinson should be presumed unless the state is able to rebut it. And as to the ability of the UCAO to rebut prejudice, there has already been a significant communication between Mr. Blank and the entire prosecutorial team, including the county attorney and potentially others in that office who are not on the team, about his experience and his Blank's experience. Further, it appears that no effort has been made by UCAO to mitigate the possible prejudice from Mr. Blank's personal conflict, as he remains on and is still the Blank, the lead of the prosecution team. The UCAO should be disqualified from prosecuting this case. Cases from other jurisdictions are instructive and support this conclusion. In People v. Connor, California Supreme Court considered the disqualification of a prosecutor's office where a prosecutor was a witness to and potential victim of the defendant's alleged criminal conduct. In upholding the trial court's determination of a conflict, Connor Court notes, because of the dramatic and gripping nature of the circumstances, the pervasiveness of the communications regarding the prosecutor's relationship to the incident, and the difficulty in gauging their cumulative effect, there was substantial evidence supporting the conflict. The information was disclosed to a substantial number of his fellow workers, and the size of the felony division, 25 attorneys, was relatively small, supporting the assumption that there was a commendable camaraderie which exists among these officials. The court concluded, While it may be difficult, if not impossible, to prove that a bias of the DA's office will definitely affect the fairness of a trial, the trial court is in a better position than we are to assess the likely effect of the shooting incident. We will not disturb the court's conclusion that the DA's discretionary powers exercised either before or after the trial, for example, plea bargaining or sentencing recommendations, consciously or unconsciously could be adversely affected to a degree rendering it unlikely that the defendant would receive a fair trial. The supervisory nature of Mr. Blank's position with the UCAO also constitutes the need for disqualification of the entire UCAO from the prosecution of this death penalty case. In State v. Tate, State v. Tate, the Tennessee Court of Criminal Appeals concluded that the entire District Attorney General's office staff should be disqualified from participation in a prosecution due to the Attorney General's conflict, having first appeared as a judge in the case, then becoming employed with the prosecutor's office. What's with the switching teams mid-case? Go on, guys. You can't do that. The Tate Court, I guess there's always cases going, but you can't on the same case, you can't play on both sides. The Tate Court commented that the prosecutor, as the representative of the people in the state criminal prosecutions, must always endeavor to promote the public confidence in the integrity and impartiality of the criminal justice system. And the prosecutor should be disqualified either based on an actual conflict or the mere appearance of impropriety. In finding that the disqualification should extend to the entire office, the court noted that there were no screening procedures. The prosecutor maintained the role of supervisor, and there was open discussion of the case amongst him and other prosecutors. In determining that the appointment of an entirely new prosecution team was necessary, the Tate Court found the perception of a fair trial is just as important as the reality. The perception of a fair trial is critical in any case, and nowhere more than here, where Mr. Robinson's life is in the balance, because as they say, death is different. The rigors of the Eighth Amendment and the United States Constitution, Article 1, Section 9 of the Utah Constitution, demand exacting scrutiny of those tasked with enforcing the law. These protections demand the disqualification of the UCAO. Based on the foregoing, this court should find that Mr. Blank has a conflict of interest and must be disqualified. The disqualification should extend to the Utah County Attorney's Office because no effort has been made to shield the prosecution of this case from his conflict. Respectfully submitted, Catherine Nestor, Michael Burt, Richard Novak, and Stacy Visor, attorneys for defendant Tyler James Robinson. We've got the certificate of service and some exhibits. These are voluntary statements of the UVU campus. This is for, let's see, the name CG. Prior to arriving at the UVU campus, I dropped off my son at my in-laws to babysit him. My friends picked me up there, and we headed to the Charlie Kirk event. We parked, walked around the place where the location on campus where the event was being held. We got to the event area and made our way down to the front row in the corner of the barricade. So we were right in the front row on the left. If you're facing the booth, we arrived around 11:19, I can't see. At that location, I actually just checked my call records. We got there at 11:09 or 11:04. I was on the phone with my other friend, Blank, who was already there. We were trying to find him. He was in the front row, right in the center, between then and the shooting. We were just killing time. That's a K. We were just killing time and playing on our phones. After a while, things were starting to ramp up. And the crowd got there. First glimpse of Charlie as he something pictures with the UVU Turning Point. They were taking pictures. Yeah, this is just one. I think we get just all the witness statements that were cited up above, so we only got a little glimpse of this.
Love you, bye.
Okay. Love you, bye. Where are you going? Okay. Have fun. Can I brag on my son for just a minute? He just, like, this is his first day home. Yeah, these are just all the statements, and they're we'll get these later on in the trial. But I was in shock and fight and flight mode for a couple hours. That atmosphere was pure panic. I was scared for my life. It's the waiver for the parent. Somebody who had a very close visual the whole time. I was in tears, just praying. Eventually made it back to my car, and I gathered myself to be able to drive, and began the slow process of getting off campus. And we've got the maps, more statements, a lot of statements. Let me brag on my son while we do this. Can I do that? It's his first full day back with family after being at college the whole time. And he's leaving right now to go to the senior center to help just give service around Christmas. Just like, hey, I just scheduled this because I like doing nice things for people. And he worked out there. He worked there for a while, helping, playing games with people, serving food, doing all sorts of things. He's a really good kid. He's amazing. And so, like, he knew he was coming back, and he's like, I'm filling my time with things I like doing, so I'm going to go back and see some of the people I saw before. They already know him, yeah. So, he's just awesome. All right. That said, I think we're done with the reading. There's more. There's a lot of statements on this one, but it's. I think we've got the gist of where that was heading, and understand that one pretty well. We could do a little bit of court hopping. It's only 10:50, so we've got some time. And are there any objections if we go court hopping? It's too early for Thurston County to be on board. Judge Simpson's doing landlord-tenant. He's been doing that all morning. Let me just jump in real quick and see if he has anything spicy going on.
Okay. And what that will do, so if you can get that payment in, try to get that in before the court hearing. And then we'll see where we are and see if something can be worked out on this for the balance.
Okay.
Fair enough?
Mm-hmm.
Okay.
Thank
So
you.
we'll do that. Thank you.
You're welcome.
Take care. Court calls case of Glencoe Hills versus Kathy Ann Haynes and Anthony Haynes.
Marissa Gazzari, appearing for plaintiff. Your Honor, I received notification from my client that defendants paid in full yesterday, so we are seeking a dismissal without prejudice.
That case is dismissed. Plaintiff's motion without prejudice.
Thank you.
Glencoe Hills versus Miguel Lopez.
Okay, we're going to jump to Burnett.
Marissa Gazzari.
Here. Oh, there he is.
Marissa Gazzari for plaintiff. I think there's 3 defendants in this case.
Yes. And
here we go. This just started a couple of minutes ago. I'm not sure what it is. We might have to bail on this one, but.
Good morning, Your Honor.
Good morning. We will go on the record in the matter 25 CM 164, State of Wisconsin versus Savannah Vanderbeek. This date appears through District Attorney Kevin Schmidt in person. Ms. Vanderbeek appears in person with counsel Amber Sherwood. We're sat here today in this matter for a status conference. Ms. Sherwood, please update the court.
Yes, Your Honor. We haven't extended an offer, which Ms. Vanderbeek does intend to take. We are asking for something out about a little over 60 days. The deal requires a prepayment of restitution, and Ms. Vanderbeek would like to get the funds together before we make our plea and sentence.
How much is the restitution?
The restitution request is, one moment, make sure I have it correct.
There's no restitution. It
Oh,
was just
it's
the
the fine.
court costs.
You're right. I apologize.
Okay, so court costs and fees.
Yes, it would be $443 is the
All
offer.
right. I do want to say, Ms. Vanderbeek, you look like you're doing well.
Yeah, thank you. Or yes, Your Honor, thank you. Much better anyways.
You look healthy.
Yeah. Thank you so much for noticing.
I'm glad to see that. Okay,
Clean and
So
sober.
how long does she need? Couple
Change your
months?
life.
She said about 60 days, Your Honor.
I'm going to call this the baby gate court because that baby gate is, it's a baby gate. It's a child gate. It also works for Chihuahuas, and that's about it. Any other dog can just step over it.
February 10th is almost 60 days. Would that work? Does that work?
That works.
You have your pick of the time. I had a day open.
Whatever works for the state. I also have a pretty open day that day.
1 o'clock. Does that work?
Does that work for you? 1 o'clock? 1 o'clock works.
1 o'clock on February 10th. 1 o'clock, February 10th. Ms. Vanderbeek, I do want to say that I'm very glad to see that you look like you're doing really well. You look like you're sober.
Thank you. Thank you, Your Honor.
And I can tell that you have a new spirit in you and a new, I guess, you on life, I'm going to guess.
Yeah.
Okay.
Thank you so much.
So we'll see you on February 10th.
Thank you so much. All right, we're just going to grab your paper.
Josh, the link I just texted you, the link you sent for the document just sends me to a login page. Let's see. Let's go to Judge in the breakout room. Please make sure your audio is connected, full name displayed, and mute yourself until you are called. Can you guess which judge this is? Just quick guess. Anybody? It's our new judge. It is. Travis County, Texas. I want to see her pop back in. I think she's doing landlord-tenant stuff, so we're probably not going to stick around very long. But let's see. So let's keep that one there. And, what part of mute yourself do you not understand? Could also go to Kansas if they have anything going on. Let's see. Yeah, we've got a puppers in Kansas. 13th Judicial. So give me a second. We're going to bring the puppy on. Michael Graham, do you have a dog with you? If there's a dog in the room, could you do your dog ownerly duties? Yeah, you. Show us there we go. There we go. Got a pup. Who's a good boy? Thank you, Josh. Can we see it a little better? Because we can only see an ear. Ashley Wise, what are you doing? She's walking on the wall. There we go. Yeah. We just want some kisses. That's a big dog. It's a big dog. Oh, we've got two. We got two. Are they pets? What kind of dog is that? Staffordshire Bull Terrier? What? They're having a face-off. Can we get you and your family a pup? Allie B from Tennessee. We have allergies is the only problem. We've got some kids that are extremely sensitive to pets, allergy-wise. There's some big boys. Nope. Michael did not want a kiss. He got a kiss anyway. Dog will sneak one if he can. Okay, Josh has sent me another document. Give me a second. We might do a little more reading later today. Of course, it's a Georgia case. Oh. trying to remember what this one was, Josh. Hang on. I have the hiccups. Oh, he's about to get a mouthful of dog tongue if he's not careful, yawning like that. Okay. Give the dog some camera time here. That's not, Michael, I'm fine with you being in court. I realize you have a court appearance, but we'd like to just see the dog. If you could. Let's see. He's going for puppy sympathy from the court. There we go. There we go. Keep calm and carry. Wonder where he stands on that issue. Looks like we're about to get started here. Just waiting for the judge.
Hey, Brett, discuss it with my client. I get where you're at. We're going to ask that it proceed to trial only so we can keep the speedy trial clock ticking.
Brett's muted. Here comes the judge.
Okay. And then, by the way, there's lots of speedy trial. He was only arraigned in November. So there's lots of time on that speedy trial clock. So if we're looking at a shortened date, I don't think it'll make any difference.
Okay.
I want to see that attorney take down the guitar and just play a little bit. Michael's going to fall asleep.
Okay, Jim and Brett, your next case.
Jim and Brett.
Your Honor, Winston Smith.
Okay.
No, I have to. You should. Your name there.
It's right here.
Case is entitled, we'll go on the Zoom record. Case is entitled State of Kansas versus Winston Smith, 25 CR 167. State appears by Assistant Butler County Attorney Brett Sweeney.
Diet Dr. Pepper.
The defendant, Mr. Smith, appears in person and by court-appointed counsel Jim Watts. This matter does regularly come back before the court this date, and this is on the pretrial conference plea docket.
We are in Kansas.
And announcements to the court at this point, Mr. Watts.
Your Honor, we would ask this case be proceeded to trial. We're asking for to proceed to trial so that the speedy trial clock can continue to run. It's our understanding the state will be asking for a continuance. I think the primary witness or one of the primary witnesses is not available.
Thank you, Mr. Watts. And announcements to the court, Mr. Sweeney.
Your Honor, that's accurate. The primary witness is not available, so the state would be requesting a continuance. That being said, there's also been some kind of alternative plea discussions. So we had discussed maybe short setting this to a date where maybe we could make an announcement on potentially a resolution here.
All right. Thank you, Mr. Sweeney. Court does grant the state's motion for continuance.
Gosh, this is a huge document. You
or
sent.
does schedule this for, once again, pretrial conference plea docket, Friday, January the 9th, Friday, January 9th at 9 o'clock. The subsequent jury trial is set for beginning on Monday, January 12, 2026 at 9 a.m. Jury trial Monday, January 12, 2026, 9 a.m. Will that work for counsel, Mr. Sweeney?
It will, Your Honor. Thank you.
And Mr. Watts?
Yes, sir. Thank you.
Crazy Cat Queen, congratulations on 15 months and your new
Or
knee.
does continue, Mr. Smith, on the bond previously posted. And Mr. Smith, I do order you to stay in contact and communication with Mr. Watts and your bail bondsman. Keep them both advised of your current address, telephone number, place of employment. You do need to reappear by Zoom process at either Mr. Watts's office or at the Butler County Judicial Building on Friday, January 9, 9 a.m.
Okay.
Mr. Smith, any questions?
Yes, sir.
There being nothing further to come before the court, court is in recess. Mr. Smith, you're free to go. Have a good day.
You too. Thank
All
you.
right.
What about the dogs?
Okay.
What about the doggos? This guy. What are we seeing? I think the dogs are outside now. Trying to see if we have some other courts we can jump to. Hold, please. Judge Middleton is doing landlord-tenant issues.
Where would you like me to start? You're right. You're good for right now, for right there. All right. We spent a lot of time on this, and
Judge, this is the
we
first
were-
hearing, I think, actually.
is it?
Yes, I was out of town for the
Oh,
first
it's
hearing.
adjourned. Yeah,
It
we
was,
had, this is a matter of money. And I don't, have you guys spoken?
I did not receive any communication from plaintiff's counsel. I was unaware which attorney from the law firm would be appearing. But like I said, I have not received any communication from plaintiff's counsel.
All right.
You guys should probably talk to each other.
Miss Spike, speak, come up and have a seat. Speech. All right. Now this is, that's Russell's sword. Oh, let me take this right out. Don't, nobody go away.
We're not leaving, Judge.
Be right back.
Where's Judge Tepe at? He's one of our live courts. Where's he out of? Just remember? Warren County. That's so many places. Warren County Court. Let's see what he's doing.
$1 a month, if my math is correct, and how are you going to pay that back?
Get a job or two.
Okay. All right. The court has considered the statements made here today, the purposes and the principles of sentencing, the relevant seriousness and recidivism factors. I am going to find today that you are amenable to community control, so I'm going to place you into community control for a period of 5 years. You will be subject to the supervision of the Warren County Probation Department. You're ordered to refrain from the use of any drugs, illegal drugs, alcohol, or marijuana. You're not permitted to use marijuana in any form. Do you understand me?
Yes, sir.
There's restitution owed of $80,617 to Walmart. You are trespassed from all Walmart stores. You're not permitted to go into Walmart anymore. You understand that?
Which is worse, no weed or no
I'm
Walmart?
ordering you to serve 180 days in the Warren County Jail. You have credit for the 5 days you've already served. You are also, I'm going to find that you're indigent for the purpose of any fines, costs, or other financial sanctions, because I want this restitution paid. Now, you're also subject to a discretionary period of post-release control, which I just spoke about. Do you want me to go over that with you again?
Yes, sir.
All right. You have a right to appeal the court's decision of your sentence to the 12th District Court of Appeals. If you want to appeal, you must file your notice of appeal within 30 days of today's date. If you can't afford to pay for the transcript or anything necessary for your appeal, including an attorney, all of that can be provided to you at no cost. Now, I am remanding you into the custody of the Warren County Sheriff to begin serving your jail time. I'm going to have your probation officer looking into some sort of inpatient treatment. Now, if she arranges something, I will suspend further execution of the jail time while you are going through that treatment. You will be placed on a monitor while you're in that treatment, and then at the end of that treatment, I will determine at that time whether I will further suspend the 180 days. So you owe right now 175 days of jail, and I'm telling you right now, if you're going to go through the treatment, you're going to go back to the jail. I'll determine then whether I'm going to make you serve the rest of the days. But if you don't have a solid plan in place for this restitution, if the restitution is not going to get paid, you're most likely just going to be sent to prison and serve out your sentence there. Do you understand me?
Yes, sir.
Pregnant? All right, this time there's the Warren County deputy standing behind you. I'm remanding you into his custody to begin serving your sentence, and you'll let me know about the treatment, right?
Yes, Your Honor.
Okay.
One question, Your Honor.
Yes, sir.
If treatment becomes available, will the court, it's a lot to ask, but will the court absorb the cost of the GPS because she's got $80,000 to pay and she's got issues with other places?
I'll talk with the probation officer about that.
Thank you.
$80,000.
175 is what she owes. There's going to have to be an amended.
Yes, I'll just do 175 and then somebody.
Yeah.
It's a lot of restitution.
All right, Mr. Gibbs.
What should he burn down somebody's truck?
This is, you ready, Deb?
That's a
This
big
is
guy.
case number 25CR42932, the state of Ohio versus William Burr. Mr. Burr is before the court with his counsel, Mr. Gibbs. Ms. Tranter, on behalf of the state of Ohio, we are here for sentencing. Ms. Tranter, anything on behalf of the state?
Nothing further than what we discussed, Judge.
Anything from probation?
Nothing further, Your Honor.
Mr. Gibbs?
Yes, Your Honor, I would just like to note, in discussions with my client, he has repeatedly and very sincerely expressed his apologies for this situation and very deep regret. He is truly taken this as a wake-up call and a time to look forward. And he's also experienced some fairly serious health issues related to his cardiac health. And my understanding is that he has some level of a cancer diagnosis. somewhere in the treatment stage on that. Given all those, on the positive side, Your Honor, he has obtained a new job, with much better compensation that's going to be starting in January, and is certainly looking to take positive steps forward from here on out.
Mr. Bureau, is there anything you'd like to say?
Where'd you get your tie?
All right, the court's considered the statements made here today, the purposes and the principles of sentencing, the relevant seriousness and recidivism factors. The court does find that the defendant is amenable to community control, so I'm going to place you into community control for a period of 3 years. You'll be subject to the supervision of the Warren County Probation Department. You're ordered to refrain from the use of any drugs, alcohol, or marijuana. Do you understand? You're ordered to successfully complete substance use disorder treatment. You're ordered to complete the Thinking for a Change course. There's restitution owed of $16. You are trespassed from the Miami Valley Gaming. Do you understand that?
Yes, sir.
Now, my understanding is that you have claimed that you are a veteran. We cannot find any verification of that. Do you have a DD-214?
No, sir. I can't get it.
Why?
From my understanding, they wiped it clean.
Uh-oh.
Without that, I cannot consider you for Veterans Court. I am going to order you to serve 30 days in the Warren County Jail. You have 0 days jail time credit.
What?
At
Do
this
vets not
time,
get-
I'm going to
It
stay
doesn't check out.
execution of that 30 days pending.
The government wipes
report
my
from your
military
probation
record. Everyone
officer
gets a
over the
DD
next couple of
214
months
for
to see how
discharge.
you're doing. And then otherwise, we'll have you schedule that 30 days with the probation officer. You're also subject to a discretionary period of post-release control, which means if you are sent to prison upon your release, the adult parole authority may supervise you for up to 2 years.
You're some elite
If you
SEAL
violate
team.
that supervision, you can be returned to prison for up to 1/2 of this court's original sentence. If your violation is that you commit another felony, you can be returned to prison for 1 year or the period that you have left on PRC, whichever is longer. That time would run consecutive to any additional prison time that you get sentenced to. You do have a right to appeal the court's decision of your sentence to the 12th District Court of Appeals. If you want to appeal, you must file your notice of appeal within 30 days of today's date. If you can't afford to pay for the transcript or anything necessary for your appeal, that can all be provided to you at no cost. If you cannot afford an attorney, I will appoint one for you at no cost. Ms. Tranter, is there anything else?
No, sir, thank you.
Mr. Gibbs?
Just, Your Honor, a quick request for clarification on the 30 days. Am I understanding correctly that it's stayed currently, and is that going to be stayed indefinitely if he's in compliance with community control?
Possibly.
Okay.
Possibly. Okay. Any questions?
No, sir.
All right. Your probation officer going to want to talk to you this morning. If you'll head back down to court services, please.
I've never heard of somebody, their military service being wiped off. That doesn't sound right. What's Judge Clark doing down in Florida? I know he's got some felony cases going on.
Any other questions? Mr. Ferrer, any questions?
No questions. Look at this.
Well, you can call your next witness. No additional witnesses. State have any witnesses?
No, Your Honor.
What's the state's position?
Your Honor, this defendant has 6 previous drug charges and 6 previous resisting officers without violence. I understand the bond set here.
I believe all those when I was a minor.
So just, we're asking for a reasonable bond.
I would,
Meredith?
if I'll take an ankle monitor if possible.
Mr. Meredith, any other argument?
Yeah, he's willing to take an ankle monitor, Judge. And I didn't ask him, but I'm sure he would show up for each court day because he is local.
It's a Christmas
In
jacket.
count one, the bond of $750,000 is truly excessive, as is count 2 and 3. Counts 4 and 5 are both misdemeanors and set at $5,000. I think those are excessive as well. I think the misdemeanors should be set at $1,000. Count 3 is a simple possession. And count 2, I mean, they're both third degrees. I think they should be set at $5,000. And then count 1, if you set it at $25,000, that would
That's got to be distribution.
basically stretch Mr. Bird's financial resources to be able to get out.
All right, I'm gonna grant the motion on the conspiracy to traffic or the trafficking in methamphetamine over 28 grams. I'm gonna reduce it from $750,000 to $150,000. The use of a two-way communication, I'm going to reduce it from 50,000 to 5,000. Possession of a controlled substance, from 20,000 to 5,000. Possession of marijuana, less than 20 grams, $1,000, and possession of paraphernalia to $1,000. That's the best I can do. We need another court date for Mr. Byrd.
Yes, sir. If we could have the February pretrial.
February 19th at 9 o'clock.
He's not going to make that bond.
Your Honor, I call Keandre Paul.
Mr. Hall?
Mr. Hall.
Mr. Paul is here before you in case 253199. We're waiting on a report from Dr. Rayleigh. It's my understanding he hasn't been out to see Mr. Paul yet.
Okay, and who's it from?
Rayleigh?
Okay. Yeah, never, okay. Let's set it for January 23rd, and hopefully he'll have the examination prior to that.
Okay, see you next month. Okay. All right. I have Heather Johnson. Your Honor, this is Heather Johnson, and we're here before you in case, she's got 3 cases, but we're here on case 252770. There was an order to show cause on Terry Montgomery, and he was not found by the Bay County Sheriff's Office, so he was not served for today.
All right. Who is he to this case?
He's the victim, Your Honor.
Have you had any contact with him?
I have not, Your Honor.
All right. What's the state intend on doing on this case?
The state would ask if we could have this rescheduled for next month to see if we can have another chance to try to obtain the victim before we make any final determination on that.
I'll set it for January 23rd at 9 o'clock, and I'm going to continue the motion to show cause.
I got Eric Odom.
Mr. Odom?
There's a lot of in custodies. This
This
court
is
has a
Mr.
jar,
Sullivan's
like a
case,
big
and we have a resolution
bottle of
today.
hand wash.
So in
there
case
on
number
the railing.
253635, he'll withdraw his previously entered plea of not guilty and or plea of no contest to count 1, possession of a controlled substance, a 3rd-degree felony, maximum penalty 5 years in prison, and count 2, possession of paraphernalia, 1st-degree misdemeanor, maximum penalty year in the county jail, will be adjudicated guilty of both. Time served on the misdemeanor and have 48 months of probation. On the felony with bars to bed Keaton and the aftercare component, court costs and fines of $1,078, 100 hours of public service work at the rate of 8 hours a month, but he can substitute NA meetings for community service work hours, $20 a month for cost of supervision, DNA sample if one's needed, and forfeit seized items. And that is the agreement.
That's the agreement with the state?
Wow, she read that off in one breath.
All right, sir, you can state your name.
Eric Odom.
Mr. Odom, you heard the announcement of Ms. Beasley, is that correct?
Yes, sir.
Is that your understanding of the agreement with the state?
Yes, sir.
Has anybody promised you anything different?
No, sir.
Are you under the influence of any drugs or alcohol this morning which would impair your ability to enter the agreement or understand any of the terms and conditions of it?
No, sir.
I've been handed a plea waiver and consent form. There's the front page. On the second page is the signature of the defendant line. Is that yours?
Sir.
Have you had a chance to read that agreement?
Yes, sir.
Have you had a chance to go over your case with Ms. Beasley?
Yes, sir.
Have you had sufficient time to speak with Ms. Beasley about your case?
Yes, sir.
Are you satisfied with your lawyer's advice and counsel?
Yes, sir.
Do you understand that by entering this plea, you're waiving your right to go to trial?
Yes, sir.
You're waiving your right to require the state prove the allegations against you?
Yes, sir.
You're waiving your right to have your attorney cross-examine the state's witnesses and contest their evidence. You're waiving your right to present any defenses that you might have to the allegations.
Yes, sir.
You're waiving your right to subpoena your own witnesses to come to court and testify on your behalf.
Yes, sir.
You're waiving your right to testify to remain silent at the trial, which would be a decision you'd have to make.
Yes, sir.
You're waiving your right to appeal anything but an illegal sentence.
Yes, sir.
Are you doing this for your own free will?
Yes, sir.
Mr. Odom, do you feel this plea is in your best interest?
Yes, sir.
You understand if you're not a citizen of the United States, you may be subjecting yourself to deportation proceedings by entering the plea?
Yes, sir.
I'll accept the stipulation. Fine as a prima facie case. I'm going to find that Mr. Odom's plea was freely and voluntarily made after consultation with his attorney. I'm going to accept it. He's adjudicated guilty of count 1, possession of a controlled substance, and count 2, possession of drug paraphernalia. On count 1, he's placed on a term of probation not to exceed 48 months. He's ordered to pay fines and costs of $1,078. He must complete 100 hours of community service work at a minimum of 8 hours a month through the Bay County Work Program. I'll give the Florida Department of Corrections the discretion to amend that to the direction of a probation officer. His cost of supervision will be $20 a month. If he's required to give a DNA sample, he must submit one. He'll forfeit all seized items. That's a special condition of his probation. He must enter and successfully complete the Keaton House program, and the aftercare program. This will be a bars to bed, which means you will remain in the Bay County Jail until a bed becomes available at the Keaton House. Any violation of the jailhouse rules
Bars to
or
bed.
the Keaton House rules can serve as a basis for an affidavit of violation of probation. On the community service work hours, you may substitute NA meetings for the community service work hours. Possession of paraphernalia, you're sentenced to the time you serve in the Bay County Jail, given credit for that time. The sentences will run concurrent. Mr. Odom, you have 30 days to file your notice of appeal if you wish to appeal your judgment sentence. If you'd like to have an attorney to represent you and you can't afford one may be appointed to represent you at no charge. Good luck to you, sir. You need to step over and be fingerprinted and speak with the probation officer.
And I'll step aside for Ms. McCarthy.
Ms. McCarthy?
There we go. That's from Josh. Tells us.
Yeah, Jamie's out there.
We got something spicy here in Judge Oakley's court from yesterday we need to see. Give the judge a minute. Just get the vibe of the courtroom first. It's quiet. Judge doing a little reading.
I apologize, sir. There's nothing getting out of the prosecutor. She'll have to be advised of her rights.
Okay.
Yes.
So, Ms. Frazier, here's the
Did we see
question.
this one already?
Ms. Frazier, here's the question.
Saw this one.
Do you want me to adjourn the pretrial so you can hire your own attorney, or do you want to just? Pardon me?
On my own, because it's evidence that y'all.
Okay. 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 All right. All right. I don't have any evidence.
Just go trying to get.
All right. So you want to represent yourself. All right. So let's set it for trial. Do you understand the difference between a jury trial and a bench trial?
So you like the paying for it.
Pardon?
Leeway.
Okay. Okay. Is there a question there for me? I'm sorry. What's the question?
Hire leeway to run the meeting.
You mean, can you hire one of our attorneys that are in here?
Leeway, the state.
I don't know if you can hire them or not. I don't deal with legal aid.
Set that. Okay. All right.
You can hire anybody you want to. I'm not,
Yes, sir.
yeah. So, all right. So you want me to give you another date so you can hire an attorney? All right. I can give you a February date. That gives you all the month of January to get somebody lined up.
Oh, I'm not gonna even draw flowers.
Okay, but I'm not gonna make somebody talk to you. Right.
Maybe let's speak to the prosecutors and board that.
So, can I have a February pretrial date?
With Judge Parker.
Judge, she wants to speak back to Sammer. I don't know if that's a good idea. Oh, I know. You never told me I'm gonna draw. You told me.
Let me ask you this. What does it matter? He asked me if he could withdraw. Obviously, he doesn't want to represent you. And I said, yes. So he's off the case. What's it matter?
We saw this one yesterday.
You want me to tell you? I'm going to tell you why. You've got a bad attitude. You can't get along with anybody. You've gone through 3 of our court-appointed attorneys. Ma'am, you asked, I'm telling you. So I'm going to give you a court date. It's going to be when, February? Ma'am, do not talk.
February 12th.
February 12th, what time? 9 a.m. Have a seat. We'll give you a paper notice, and then you're going to leave my building without talking to anybody. Are you clear on that? Ma'am, you're going to take your notice, and you're going to leave my building. Ma'am, I'm talking to you. I'm talking to you. Do you understand that? We're going to give you a notice, and you're going to leave the building without talking to anybody else. No, you're going to sit down right there, and I'm going to give you a notice, and then you're going to leave my building. You're not going to stop and collect $200. No, you're going to leave my building. Any paperwork you want, you can get online. You're going to sit there, and you're going to be quiet, and you're going to get your notice, and you're going to leave. Anything other than that, I'll hold you in contempt. Heather, this Abdallah that you gave me earlier today that somebody made a deal on, it was a double parking.
Angela took a plea.
So that's
Yeah.
the little note, 14 days, he's 14 days to pay his $350.
That's pretty good because in this community. Gonna get it under control on 26. In one of the files, they had the prosecutor as 7337. So I kept doing it and I kept doing it. I kept calling the wrong person.
Well, she's standing there filling in on that lady that was so screwed up.
Yeah. Just wondering if you want to write on the blue ROA for the civil action.
If you were done, might well done, it's a paper.
Oh, okay.
The warrants all canceled. The warrants were, I moved them. This wasn't, yeah, they were all canceled in lien. They just weren't canceled in. The
They're having-
PD canceled them all.
This is from yesterday. They had some court issues.
We just
Check in with
did
Judge
not
Webster.
vote for it. Canceled them.
Well, we have Amethyst. Is it Stout or how do you pronounce that? Stud?
It's
Stout.
Stout. Okay, let's take up your case. Although, where's your attorney? I don't see Mr. McClendon.
He told me to be here at 10 a.m.
Yeah, you're here. Where's he?
Missy, can you email Mr. McClendon? That's not
I've
like
already done that. I'm just waiting to hear back from him.
he's usually quite prompt.
Where's Mr.
Yeah, or I'll be sitting here. I'm just gonna
Very well.
go mute and dark.
Okay. Nobody's in the waiting room and nobody's in the courthouse, huh?
It's Friday, Judge.
You.
I just heard back from him and he's stuck on another docket bill. He'll be here as soon as he can.
Oh, another docket thing.
A show cause. Order a show cause, Judge.
Okay, well, we'll just kind of wait here, Miss Stout, until he gets out of that other docket.
Yes, ma'am.
That means he's in front of another judge that's taking a little more time than they must have thought.
Every judge thinks their court's most important. While we sit here and wait, let's see if we have anyone else we can go check in on. So we've got some arraignments. First appearances for Judge Mercer. Yep, he just finished. Can't do those. Judge Molly Hennessy. Hasn't started. She'll be a second. Judge Hart. You go back to him, also in Kansas.
Bauer as my court service officer. I just had a in-person meeting with him at 8:30 this morning, and I got it rescheduled for next Friday to in person. Is that anything to do with what you're talking about?
Well, this for your pre-sentence investigation report, I do order you to contact court services and just confirm that that's what Mr. Bauer has planned to meet with you on.
Josh, have a
but
Merry
their
Christmas.
number is
316-867-5309. Josh, have a very Merry Christmas. Thank you very much. Appreciate it. Thanks for sending me a huge document to read right at the last minute here. It's massive.
Investigation report. Otherwise, Mr. Graham, the court does continue you on the bond you have previously posted. I do order you to stay in contact and communication with Mr. Fabre and your bail bondsman. Keep them both advised all times for an address, telephone number, place of employment.
Absolutely.
Any other matters to come before the court?
No, Your Honor. Thank you.
There being nothing further to come before the court, court is in recess. Mr. Graham, have a good day.
Thanks, sir. You too. Okay, I gotta go.
Oh, it's gone.
Oh, yeah.
I gotta go. How do I go? I'm still here.
And Joe, your next case?
Judge, Mr. Cody Hills, he's present.
Cody didn't skip arm day. You guys are ripped.
And Judge, I don't think anybody else is at detention center or court security, so I don't know if they want to check out or not, but they don't have to be here, I don't think.
What did your client do that you want everyone to be gone for?
Okay, thank you, Mr. Favre. Cases are entitled State of Kansas versus Cody Hills, 20 CR 321 and 25 CR 238. State of Kansas appears by Assistant Butler County Attorney Amber Norris. The defendant, Mr. Hills, appears in person and by court-appointed counsel Joe Favre. This matter does regularly come back before the court this date on the pretrial conference plea docket. And announcements to the court, Mr. Favre.
Judge, I think we have both cases in front of the court today. We have reached a plea agreement that encompasses both cases. In 20 CR 321, Mr. Hills will be entering a plea to an amended Class B domestic battery. That is a plea of no contest.
That's 5 years ago.
In 25 CR 238, Mr. Hills will be entering a plea of no contest to counts 1, 3, and 5 of the current information, which are aggravated domestic battery level 7, criminal restraint class A, and endangering a child class A. And then state will dismiss criminal threat counts 2 and 4. At sentencing, recommendations will be mid-box and follow presumption. We anticipate Mr. Hills will be presumptive probation in these matters.
And Ms. Norris, is that the state's understanding of the plea negotiations?
That is accurate, Your Honor. Thank you.
You got a 2020 case and a 2025 case?
And Mr. Hills, Mr. Favre has advised the court you do wish to enter a plea of no contest in case number 20 CR 321 to amended count domestic battery class B misdemeanor, and you do wish to enter a plea of no contest to counts in case number 25 CR 238, counts 1, aggravated domestic battery, a level 7 person felony, count 3, criminal restraint, a class A person misdemeanor, and count 5, endangering a child, a class A person misdemeanor. Is all that correct?
You need to unmute yourself first, Cody.
Must unmute.
I apologize. Yes, Your Honor.
Mr. Hills, there are a number of questions that I do need to ask you prior to the court accepting your plea herein to make sure that you're knowingly and voluntarily entering your plea. Sir, how old are you?
30 years old.
Are you married or single?
I'm single.
Are you employed?
Not at the moment, Your Honor.
What type of work have you done in the past?
My main trade is a cell tower technician. I also recently have been a machinist, a CNC machinist. However, I think I'm going back and hopefully once we can get this settled, Gonna attempt to go back into cell towers, and do that.
What is the highest level of education that you have obtained?
Trade school.
Have you graduated from high school?
Yes, Your Honor.
Are you making your plea voluntarily?
Yes, Your Honor.
Have there been any promises or threats made to you which have influenced you to plead no contest?
No, Your Honor.
I understand there have been certain plea negotiations entered into between your counsel and counsel for the state. Do you understand, even though the attorneys may make certain recommendations in regards to sentence, the decision in regards to appropriate sentence is mine pursuant to the sentencing guidelines for the state of Kansas?
Yes, Your Honor.
When you plead no contest, you surrender and waive certain legal rights you'd otherwise have if you chose to go to trial. Do you understand you have the right to a speedy trial where your guilt or innocence would be determined by a jury, or if you chose to waive a jury, by a judge?
Yes, Your Honor.
Do you understand at such a trial you would have the right to confront the witnesses against you and have them cross-examined by your attorney?
Yes, Your Honor.
Do you understand at such a trial you'd have the right to subpoena witnesses who may have information favorable to you and call them to testify in your behalf?
Yes, Your Honor.
Do you understand at such a trial it would be the burden of the state to prove your guilt beyond a reasonable doubt on each element of the charges against you before you could be found guilty?
Yes, Your Honor.
Do you understand the judge and the jury must presume you're innocent until the state proves otherwise, if ever, beyond a reasonable doubt?
Yes, Your Honor.
Do you understand if convicted at
It's a lot to
such a trial,
understand.
you would have the right to ask the court for a new trial, and if denied, would have the right to appeal your conviction and your sentence to the appellate courts of the state of Kansas?
Yes, Your Honor.
Do you understand you're giving up each one of these rights if you plead no contest?
Yes, Your Honor.
Do you understand the sentences which may be imposed?
I do.
In regards to case number 20 CR 321, domestic battery, B misdemeanor, you could be sentenced up to 6 months in the county jail. In case
only
number
gonna get
25 CR 238,
probation.
count 1, aggravated domestic battery, a level 7 person felony. He could be sentenced anywhere from 11 to 34 months in prison.
It's time to jump.
If you would have a criminal history of one person and one non-person felony or less, there's a presumption you would be placed on probation.
We're going to
You
jump.
would have a criminal history of 2-person felonies or more. There's a presumption you would be placed in prison.
We're going to Minecraft
On
court.
count.
Got a hearing just started a couple minutes ago in Minecraft court. Call it Minecraft court because the bottom left-hand corner of the pictures where I am is where the jury sits, and they do pixelate that court. They blur it digitally so you won't be able to see the faces of the jurors as long as they don't stand up, which they often do. Seriously? I just got here, and you... It'll turn back on. Give them a second.
Sole charge in the indictment, that being having weapon under disability, a felony of the 3rd degree. The state has represented that we would be recommending continued probation on that.
All right, Mr. Richardson.
Thank you, Your Honor. Please the court. The state of Ohio has accurately recited the plea agreement that Mr. King is prepared to enter today. Prior to going on the record, I explained all of his trial rights to him, Your Honor, and those he waives by entering a plea. So I believe he is ready to go forward, Your Honor.
All right, the violation on the 1023 case is the incident with this case in October. Does he want to waive his right to a hearing and plead
I believe he
guilty?
did that previously, Your
He
Honor,
did,
and we would,
just did it for sentencing today.
correct.
Okay.
So we would renew that admission
so-
and proceed to disposition, Your Honor.
All right, we're good on that then. All right, Mr. King, how old are you?
56.
How far did you go through school?
12.
Are you a U.S. citizen?
Yes.
Are you able to read, write, and understand the English language?
Yes.
Prior to coming to court, have you taken any drugs or alcohol or any prescription medication within the last 48 hours?
No.
Ever been diagnosed with or treated for any mental illness?
Yes.
What have you been diagnosed with?
Schizophrenic, bipolar, and anxiety.
Are you being treated for any of those?
Yes.
What treatment are you undergoing?
All of them.
No, what treatment are you, you have ongoing treatment as a result of those conditions?
Yes, through Signature Health.
Do you take medication? I think.
Oh, yes, yes.
Why don't you tell the judge what you take if you remember it, okay?
Olanzapine and 5 other medications.
When's the last time you took anything?
This morning.
All right. Does it affect your ability to understand what's going on here?
No.
Did you get a copy of the indictment in this case?
Yes.
Any questions about it?
No.
And it's your intention to plead guilty to that charge, having weapons under disability, a felony 3?
Yes, Your Honor.
All right, before I accept your guilty plea, I need to determine that you know and understand the constitutional rights you'll be waiving, the consequences of your guilty plea, and the maximum penalty I could give you, and I need to be satisfied that your guilty plea is being made freely, knowingly, and voluntarily. I'm going to ask you questions. If you don't understand a question, let me know. If you want to talk to Mr. Richardson some more, let me know that, and I'll give you more time. You understand that?
Yes, correct.
You have a constitutional right to have a trial, either to me or to a jury of 12 Lake County citizens. Do you understand that right?
Yes.
If you go to a jury trial, all 12 members must agree to a guilty verdict before you can be found guilty. Do you understand that right?
Yes.
Are you waiving that right?
Yes.
If you go to trial, the prosecutor will call witnesses to testify against you. Do you understand the prosecutor must prove you guilty beyond a reasonable doubt at a trial?
Yes.
After the witnesses are done testifying for the prosecutor, you have the constitutional right to have your lawyer cross-examine those witnesses. Do you understand that right?
Yes, Your Honor.
Are you waiving that right?
Yes.
If you go to trial, you have the right to have witnesses come here and testify for you. Do you understand that right?
Yes.
Are you waiving that right?
Yes.
If those witnesses refuse to come to court, I'll issue an order called a subpoena to make them testify. Do you understand that right?
Yes.
Are you waiving that right?
Yes, Your Honor.
You have the right to testify at trial if you want to. Do you understand that right?
Yes.
Are you waiving that right?
Yes, Your Honor.
You have the constitutional right to not testify at trial if you do not want to. Do you understand that right?
Yes.
Are you waiving that right?
Yes, Your Honor.
If you decide not to testify at trial, nobody is permitted to comment on that decision. Do you understand that?
Yes.
If you go to trial and you're found guilty, you have the right to appeal the guilty finding. Do you understand that right?
Yes, Your Honor.
Are you waiving that right?
Yes, Your Honor.
If you file an appeal, you have the constitutional right to have a lawyer represent you in the appeal. Do you understand that right?
Yes.
Are you waiving that right?
Yes, Your Honor.
If you could not afford to hire a lawyer, one would be provided at no cost to you. Do you understand that?
Yes.
If you file an appeal, you're entitled to have a transcript of all the hearings in this case. Do you understand that right?
Yes, Your Honor.
Are you waiving that right?
Yes.
If you could not afford to copy those transcripts, they'd be given to you at no cost. Do you understand that?
Yes.
If you plead guilty today, you will not have the right to appeal the guilty finding. Do you understand that?
Yes.
Do you have any questions about any of these rights?
No, Your Honor.
Do you still want to plead guilty to this charge?
Yes.
Do you understand by pleading guilty, you're fully admitting your guilt to the charge?
Yes.
You understand by pleading guilty to this felony, you're voluntarily giving up your freedom for whatever period of time I could sentence you to prison, to jail, or to community control.
Yes, Your Honor.
Having weapons while under disability is a felony 3. It carries a 36-month maximum prison sentence and a $10,000 maximum fine. Do you understand that?
Yes.
And part of the deal here is a forfeiture of that weapon. Is that right, Counsel?
Correct, Your Honor.
Okay. All right. Do you understand that your felony conviction prevents you from owning or possessing a firearm?
Yes.
Do you understand that if a prison term is imposed in this case, you might have to serve a period of post-release control as part of your sentence for up to 2 years under the parole authority?
Yes.
If you are placed on post-release control and violate the conditions, the parole authority could send you back to prison for up to 9 months for each violation up to 1/2 of my sentence. Do you understand that?
I understand, Your Honor.
If that violation is a new felony, then you could get an additional consecutive prison sentence for that violation. Do you understand that?
Yes.
If that happens, the maximum prison sentence for that violation would be the greater of 12 months or the time left under post-release control. Do you understand that?
I understand.
Do you understand that if a prison term is imposed, you are eligible for judicial release?
Yes.
I could place you on community control for up to 5 years, but if you violate any conditions, I could send you to prison for 36 months. Do you understand that?
I understand, Your Honor.
Now, has anybody promised you I would be lenient on you just because you're pleading guilty here today?
No.
Has anybody promised you what I will sentence you to in this case?
No.
Do you understand I do not have to follow the sentencing recommendation of either the prosecutor or your lawyer?
Yeah.
The prosecutor may make a recommendation, Mr. Richardson may make one also. You understand I don't have to follow either one?
Yes, yes.
Okay. All right, have you had enough time to talk to Mr. Richardson before pleading guilty today?
Yes.
Has he discussed everything about your case and answered all of your questions?
Yes.
Are you satisfied with the advice he has given you?
Yes, I'm satisfied.
Have you been threatened or coerced in any way to plead guilty today?
Oh, no.
Are you freely, knowingly, and voluntarily entering your guilty plea?
Yes, I am.
Do you have any questions?
No, Your Honor.
All right. Ms. Mulligan, if the 1504 case went to trial, what would the evidence show?
The state would be prepared to show that on October 4th, 2025, police were called to the defendant's residence in Willoughby Hills, Lake County, Ohio, on a complaint of domestic violence. While they were there, the defendant notified them that he had a long gun, a shotgun, behind his bedroom door that was confiscated. He has previously been convicted of felony drug offenses, and the firearm was operable.
All right. Mr. Richardson, anything to add to those facts?
No, Your Honor. We would just ask to be heard in mitigation at the appropriate time.
All right. Mr. King, did you hear what Ms. Mulligan said, that the facts would show if this case went to a trial?
Yes.
And are those facts true?
Yes.
All right. What is your plea to having weapons while under disability a felony of the 3rd degree?
Guilty.
All right. Mr. Richardson?
Thank you, Your Honor. Okay, this is a written plea agreement. It just basically recites everything the judge just talked to us about.
Hey, Jeff, on page 2, I wrote that he's got taken the meds. Can you have an initial in that margin up near the top?
Okay.
All right.
Can you write okay?
Yeah.
Okay. Just put your initial up here. Okay. And then should we move to the signature page, Your Honor?
Yeah.
Right here at the bottom. Okay.
Collin grade had already happened. We played that this morning. It actually happened yesterday, and we were just catching up on what happened there. That's going to go February, I think, early next year, same time as Corey Richens.
All right, Mr. King, is this your signature on this written plea of guilty?
Yes, Your Honor.
And did you sign it voluntarily?
No, Your Honor.
Did you?
I mean, yes.
All right.
Sorry.
Do you want me to accept your written plea of guilty?
Yes, Your Honor.
I accept the written plea of guilty. Defendant was present, Mr. Richardson. Advised of all of his rights, made a knowing, intelligent, voluntary waiver. He understands the nature of the charge, the consequence of his guilty plea, and the maximum penalty. Find it to be knowing, intelligent, voluntary. Will accept his plea of guilty and find him guilty of having weapons while under disability, a felony 3. When we were here, I think last week, we discussed an updated pre-sentence report that's been done. Is there any reason not to proceed to sentencing on both cases, Mr. Richardson?
No, we are ready to go forward, Your Honor.
All right, go ahead.
Thank you, Your Honor. Again, if it would please the court. Mr. King was sentenced on a weapon under disability approximately a week before this incident occurred, Your Honor. This incident before you today actually took place at his kind of estranged but remains friendly spouse. There was a dispute about whether Mr. King had taken some keys that his wife needed. The police were contacted. They entered the property with permission. Mr. King almost immediately indicated to the officers from Willoughby Hills that this shotgun was behind a door, a bedroom door, and that they should be aware of that. He was painfully honest, Your Honor. The firearm was in his wife's apartment. He didn't try to use that to any advantage, Your Honor. He told the officers that he had received that shotgun as a birthday gift. So he largely confessed on scene. He has a long history of mental illness, Your Honor. I think Mr. King has...
He's got a history of mental illness and they give him a shotgun for his birthday?
As best I can, has learned that when you're on 5 or 6 different psychiatric medications, the worst thing you can really do is add alcohol
and guns
to your system. It not only causes the drugs not to be as effective, but can also very much impair his judgment. And I think 60 plus days here in the county jail have driven that point home, Your Honor. He is connected to Signature Health, where he can engage in whatever level of treatment they would recommend that he engage in. And I believe it's been a lesson learned, Your Honor. He is 56. His disabling offenses, I believe, are 20 plus years old, Your Honor. So, is that correct,
Yes.
Carolyn? So he hasn't established any kind of recent pattern of criminal behavior, Your Honor. So I would ask you to consider him amenable to a community control sanction.
Only the week
Appreciate
before
the
he got
court's
the same
consideration.
offense.
All right, Mr. King, what do you want to tell me before I sentence you?
Yes, I want to apologize.
Stand up.
Oh, stand up. Oh,
Yeah, stand up.
okay, I'm ready. I would like to apologize to the court and to my family, myself and my lawyer, and also you. I take full responsibility for what happened. Situation turned into a problem. And with that, with the alcohol, I've been drinking since I was 15. And that's really what I have to say. I apologize, and I'm very sorry to the courts and to Painesville. I really am sorry. I really am sorry that it had to come this, to this point. And it's a good thing that it did come to this point. That way, I'm able to get all the resources that I need in order to become a productive citizen.
Did you tell me you're going to Signature?
Yes.
Were you going to Metro in the past?
That was, yes.
Okay,
both.
so when did you change to Signature?
I've been with Signature almost, it's going on 3 months now. I've been
Okay.
with Signature Health, and my primary doctor, I guess they mingle with each other, whatnot, but.
What do you do at Signature? How often do you go there?
Once a month.
Is that for the medication?
Yes, for the medication. Yes, for the medication and other things also.
All right.
But now she's seeing me every 2 weeks since I've been here. It's been every 2 weeks.
Okay, so you're taking meds every day?
Yes, every day.
How long have you been diagnosed with those conditions? How many years?
How long? It's been 7 years now. It's
Okay.
going on 7 years.
All right. So if you had it, you've been on medication that entire time?
This entire time. But before I was being incarcerated, I really wasn't taking it all like that.
Okay.
You know, and now that I got in here, it's been helping me.
Was there alcohol involved in this October
Oh, yes.
incident? Okay, so you didn't have anything for 20, let's see, 23 years until this year. You had nothing, no offenses at all
No
until now.
offenses at all, because
So what's the common factor there?
I just stay
Taking the
home.
meds and you're drinking. And
That I know that was kind of bad. I mean, you know, for really, it was messed
well,
up.
whatever good the meds do, you get thrown off when you start drinking. And it doesn't
Yes.
Okay.
It made me black out.
All right.
Black.
All right. Well, you got to quit drinking.
I want
I'm
to.
Captain Obvious up here. Okay, you got to quit drinking.
And Senator Health was getting an injection shot, not in the arm, not in the close by the buttocks, the cheeks. Yeah.
The cheeks.
Is that what, control cravings for alcohol?
Yes.
I'm not sure what that drug is, Your Honor.
They was allowing me to, what's that, outpatient post.
Where are you living?
Oh, Euclid Avenue.
Who do you live with?
Just me and my dog.
Okay. You don't have a license?
Driver's license?
No, I haven't had a license since 1988.
Why not?
And I just didn't feel like driving.
How do you get around?
My wife, my son, and RTA.
All right. Anything else you want to say?
Oh, no. Like I said again, I'm very, very, very sorry to the courts and everybody that's in this courtroom right now, today.
All right, thank you. All right, Ms. Mulligan?
Your Honor, the state is recommending continued probation, community control with the focus on alcohol treatment.
All right. I went back and reviewed the old pre-sentence report as well as the updated report. Listen to you, Mr. King, listen to counsel. Considered all the provisions of 29, 29, 11, 12, and 13.
Thank you, Ola.
On the old case, I'm going to continue your community control, and I'm going to extend it. So it's extended until December 19th of 27. On the new case, I'm going to place you on community control for 2 years. The old case will serve 67 days in jail with credit for 67. The new case, 3 days in jail with credit for 3. On both cases, you're to have no drugs or alcohol. Obviously, you can have your prescription drugs, but you can't take any other drugs you're not prescribed. You can't have alcohol, you understand?
I understand, yeah.
And then you'll be screened. You're to continue your mental health treatment and your other treatment with Signature Health, and you're going to follow all their recommendations. Do you go to another doctor besides a Signature Health doctor?
On Metro Health with Mary Ryan.
For
We're
what?
going to jump.
Just
Ready to jump?
sleep
3, 2, 1.
disorder.
Small claims
so
and
those are the
Thurston.
only
Larry? Do we have somebody here for Ana Cecilia Gutierrez?
Thurston County, Washington, where we just landed.
Thank you.
Small claims court.
I'm not seeing anybody
Not seeing anybody.
indicating that they're here. But here for Lynn Larry. All right, come back to that. Number 2 on the calendar, Donald Shue. Am I saying that right? Sheu?
Yes, Your Honor.
OH versus
Present.
Bruce Auto. So I see plaintiffs are here. Do I have anybody from Bruce Titus?
Yes, Your Honor. Yes, Your Honor.
Mr. Rayberger, okay.
Apparently, lots of people are suing each other right before Christmas. Got to get those gifts
Number
paid
3
somehow.
on the calendar, the Rance Group versus Rebecca Freese, Frese, and Sean Braley, Brailey.
High Priestess of Grievances.
Everybody here
Merry
on
Christmas,
that
everyone.
case.
May you hold your family tight and let go of your sorrows. Be kind to others. Remember all your blessings and thank the good Lord for it all. Love you all. High Priestess of Grievances, 20 months on the jury. Thank you very much for your support. Makes you an OG. And I love that your name is ready for the Festivus celebration.
Number 4 on the calendar, Carrie Peterson versus Expedia Group.
Expedia.
Mr. Peterson, I thought I saw on the screen.
Yes, Your Honor, I'm present.
All right. Anyone here from Expedia Group?
It's good news for you, Carrie. You're going to win.
All right.
If they don't show up.
5 is going to be set for 11. Number 6, Evelyn Lay, L-E.
Here, Honor.
Versus Melina Kochhar, Kochhar.
Here, Your Honor.
Singh. Okay.
Here, Your
So
Honor.
we have everybody here on that one.
Nice. That fight is ready to go. Is that our
Number
main
7,
event?
Abdul Azimi, A-Z-I-M-I, and Abdullah Arazi, A-R-A-S-I.
Yes, Honor.
And Your Honor, interpreter is present.
Okay. And
I'm sorry, on that case, would you be able to ask the plaintiff, as the interpreter, they answer their phone so that the target interpreter can simultaneously
all right.
interpret them?
So do we have Mr. Abdul Azimi here?
آقای عبدالعظیمی.
بله، جناب قاضی.
Yes, Your Honor.
All right, you're showing up as Zahid's phone. Okay.
نشون میده شماره زاهد.
بله، جناب قاضی.
Yes, Your Honor.
Apparently he borrowed the phone for this special appearance.
And we need his phone number, so.
The interpreter should have it. He just needs to answer his phone when she calls him.
All right. Mr. Azimi, we need your phone number so the interpreter can have that available if she needs it.
آقای عظیمی شماره تلفنتون رو لازم داریم که مترجم بتونه بهتون زنگ بزنه.
همین فعلا؟
For now?
Yes, if you would provide that now.
اگر الان بدین لطفاً.
We'll all promise not to call you.
971
867-5309.
And Your Honor, interpreter's been calling that phone number and it goes to voicemail.
Well, that's.
All right, would you mention that to Mr. Azimi?
Sure.
And ask him why that's so.
آقای عظیمی من 2 بار به این شماره زنگ زدم. لطفاً تلفنتون رو وردارین وقتی تلفن رو میشنوید.
وقتی او را جواب میتم از میتینگ میبرایم.
It's because I'm in court.
دیگه در این میتینگ نمی باشم.
So when I answer that, then I'm no longer in the meeting.
It sounds like he's using his phone for Zoom. So she'll just have to translate.
All right.
Live on the Zoom call.
The clerk is telling me that apparently Mr. Azimi is using his phone for a presentation today, so he can't use it for both purposes. We'll have to address that as we go forward.
Okay.
How about Abdullah Arazi? We have someone here for Mr. Arazi in this case?
آقای عبدالله آراسی.
I'm not hearing or seeing anyone.
Well, if the other guy is not here, we won't need to do much translation.
Back to that. Number 8 on the calendar, Stephanie Daly versus Mary Baker and Matthew Schultz. Stephanie Daly here.
Probably 11:30. Yes, I'm here. Right. Okay, thank you.
Mary Baker.
She's on the phone.
Thank you. And Matthew Schultz.
Right here. Baker's in present.
Thank you.
Present in person. Matthew Schultz in person.
Okay.
All these
Number
people
9,
are suing each other.
Veronica Zavala, Zavala.
I'm here, Your Honor.
Where?
Thank you. And Ricardo Covarrubias.
Here, Your Honor.
Thank you.
Judge can see more than we can. He's got the
And
big
number
screen.
10, Justin Vaughn. I see Mr. Vaughn is here. Anybody here for Thurston County Transmission?
If they don't show up, you win.
1.
That's how court works. Not necessarily, but if they repeatedly don't show up, you win.
And number 11 is Andy Furler, Furlar. A person present?
Paige and Andy.
About Sarah Harrington.
Can't both miss. Just have to refile that one.
Right. All right, first I'm going to go back to number 1 on the calendar. That's Ana Cecilia Gutierrez versus Lynn Larry, case number 39034. Anybody here on that case other than the interpreter who's in the courtroom?
We paid for the interpreter, but
all right. That case was on the calendar for 8:30 this morning. It is now 9:11 a.m. and no one is here. So at this point, I'm going to dismiss that case and excuse the interpreter. Thank her for being here this morning.
Thank you, Your
I
Honor.
appreciate it.
and pay her. You'll pay her too. I see a little puppy, Don Shu and Young O. Have is that a puppy in her arms or a cat? I can't tell. Katie Plaintiff has a question. That's not how you raise your hand on Zoom, by the way.
All right, I signed that order.
Can I get an amen? No, I don't know what she's doing right now. That's Bicoastal Lady.
All right. Just to let you know, folks, that we have mediators from the Dispute Resolution Center present today. I want to go over some information with you all at this point and then have the dispute resolution people take over. And on the Azimi matter, Madam Interpreter, are you going to be able to interpret simultaneously as we go through this?
Your Honor, I haven't been able to establish communication through through cell phone with him, so I won't be able to do simultaneous.
Unless we have him go off the screen and then you can contact him by phone.
Yes, I can do that, of course. We can do that.
All right. Let's let Mr. Azimi know that that's what we want to do. Have him go off the screen and then answer the phone when you contact him.
Yes. آقای عظیمی شما باید از زوم خارج بشین. من به شما تلفن میکنم. شما تلفنتون رو جواب بدین که من بتونم اون چیزهایی که قاضی میگن تو دادگاه برای شما ترجمه کنم. باشه؟
درست است. مشکلی نیست من در زوم نباشم.
Your Honor, interpreter said you need to exit out of Zoom so interpreter can call you. Please answer your phone and I will interpreter will interpret everything simultaneously. And he said it's not a problem for me to exit Zoom.
All right. Let's direct him to do that. And then you contact him by phone, and once you have established that contact, I will begin my presentation.
Yes.
All right?
Yes.
Thank you.
پس نه اشکالی نیست. شما از زوم خارج شید. من به شما تلفن میکنم. تلفن رو جواب بدین. باشه؟
درست است.
اوکی بفرمایید.
By coastal lady, did her case get dismissed? Was she the one that showed up late? Answer your phone. So now we're going to swear him in through the
Your
interpreter.
Honor, we are ready.
All right, thank you.
Thank you.
A moment. Number 5 is the one that needs to be heard by.
Correct.
By by Judge Meyer, right?
Correct.
And I see that Ms. Duncan is on the line at this point and not waiting for 11.
Yeah, I'm not sure why she chose to sign on it.
All right. So we should might as well just do that at this time.
Yeah.
I'm not sure why she chose to sign on.
Before I start the presentation, I'm going to go back to number 5 on the calendar, and that is Kendra Duncan versus Kazabek Moldash, Moldash. Ms. Duncan, I see you're on the screen at this point.
Yes.
All right. Your case, after hearing in front of Judge Meyer, was reset for hearing today at 11. Now I see that you're here already at 9:15, and rather than wait until 11 to let you know this, I'm going to tell you, obviously, I am not Judge Meyer, and I don't know what his answer is, and he's not here at the court building today. So we're going to have to reset this case for another day when Judge Meyer is available to be here. The reason I'm doing this, I don't want you to sit here for a couple of hours waiting for his response in this case, since he's not here. So do we have a date we can?
I mean, we could schedule it to next week, which would be December 26th. But
yeah, let's not do that.
December 26th, day after Christmas. January 2nd.
Ms. Duncan, January 16 work okay for you?
You said 16, 15,
Yes.
16?
16.
No, Your Honor, it does not.
Or January 30th.
January 23rd or January 30th?
30th would be fine.
All right. So number 5 on the calendar, case number 39349. We're going to reset that matter to January 30th. Do we want to put it at 11?
Well,
or just leave it on the regular calendar?
11 would be fine.
We'll set that specifically for 11 a.m. as well, Ms. Duncan, so that, you can schedule your time accordingly.
Thank you. January 30 at 11 a.m.
That's correct.
Thank you
All
so
right.
much.
Thank you, Ms. Duncan. You may leave. All right.
We have the Bicoastal Lady song, right? Did I make a song about that?
For everyone else now.
Pay attention.
We have 9 cases on the calendar today where both parties are present, and those cases have been set for trial. Here's how we're going to proceed on those cases. When I call your case, I'll swear both of you in. I'll hear from the plaintiffs, I'll hear from the defendants, and then I'll decide the case. I'll decide the case by applying the law to the facts that I find to be true today. I'm going to take a few minutes and discuss with you why I believe you want to take advantage of the opportunity we're going to give all of you this morning to try to settle your case without going to trial. First of all, if you choose to go to trial, what you are doing is giving up your last chance to come up with the best resolution to the problem that brings you here. Because when you choose to go to trial, you aren't asking me to come up with the best solution. You are asking me to come up with the legally correct solution. And I can assure you, in many instances, the legally correct solution is not the best solution. In fact, I will listen to your testimony, and there may appear to me to be a very obvious way to solve this problem that meets the needs of both parties. But I'm not going to be able to solve the problem that way, because that's not going to be the legally correct answer to the problem that you're opposing to me. So I'm going to have to ignore that, what I believe to be the best solution, come up with a different solution, the legally correct solution. If you choose to go to trial, you're also giving up the last chance you have to make any impact on what the solution is. Because if you go to trial, you're going to turn the matter over to me, and I'm going to solve it for you. But you're going to have no say in how I choose to solve it. Now, there's a distinct limitation in turning it over to me and asking me to solve it. And that limitation is that I know nothing about the problem that brings you here today, other than some of what you have filed in your paperwork. So if the issue is a home or apartment rental, I haven't seen that home or apartment. I don't know what condition it was in when you moved in. I don't know whether you were good tenants or poor tenants. I don't know if you made a good effort to clean up when you left or whether you just left. If it's a contractual agreement between the two of you, and particularly if that agreement is not set forth completely in writing, and the two of you have some dispute as to what the terms are, you are going to each come up here and tell me what you believe you agreed to after what I assume were rather lengthy discussions. Then you're going to ask me what the terms of the contract are, knowing that I wasn't a party to the contract. I didn't hear any of those discussions. If the issue isn't what you agreed to, but rather whether you performed in accordance with the contract, you're going to ask me to decide that, knowing that I have not been there to observe any performance. You are each going to have very different versions of whether you have or have not done what you were supposed to do under the terms of the contract. If it's an automobile accident, I didn't see it happen. I wasn't standing on the corner where it occurred. You don't have a videotape of the accident occurring. What's going to happen is you're both going to point the finger at the other party and say it's their fault, but it's not your fault. Then you're going to ask me to decide whose fault it was, knowing that the only information I'm going to have is what I hear in the courtroom today. And what we're going to hear are two people saying it's not their fault, it's somebody else's fault. And I will decide it, but you have to understand the limitations of that approach. If you choose to go to trial, the rest of us are going to sit here and listen to testimony. What we're going to hear is, in these cases, are two very different versions of the same set of facts. These versions are going to be different because what you're going to do is tell me what happened from your perspective. Now, that means your version is going to be intended to advance your best interest in this case. That's normal. That's what people do. The versions may also be different because one or both of you are choosing not to tell the truth. And you're going to ask me to figure that out. And you're going to ask me to figure that out, knowing that I don't know either one of you. I don't have any ability to sit here, listen to your testimony, and to think to myself while listening to that testimony that I've known this person for a long time. I've known them always to be honest and always to be accurate and to never exaggerate. Or I can't sit here and think just the opposite. As I've said, I know nothing about the problem that brings you here today. So I don't have any ability to sit here and listen to the testimony and to compare what I'm hearing to facts which I know to be true concerning the situation. So you may be sitting there listening to the other party testify, and they may say something, and you know certain things, and you think to yourself, I can't believe they just said that. The nerve of them. Clearly, the judge doesn't believe what was just said. Well, fair warning, I don't know those things that you know, and I may very well have believed what was said. I may have believed every word of it. Now, I can assure you, if it is your version of the truth that I choose not to believe for whatever reason, then you aren't going to be very satisfied with the resolution you get if you choose to go to trial. Now, you took the time to come here today because you know you are right in the problem that brings you here. Well, that's the nature of the trial process, that each of you, if you choose to go to trial, believe that you are correct. But I'm going to tell half of you that you made the decision to make that decision, that have made that decision to come to court, that you were wrong.
Half of you are
I'm going to
lose.
decide the case in favor of one party or the other. So as you sit here right now and you are determined to go to trial, the odds are at best 50-50 that when you leave here at the end of the day, you are going to be satisfied with the resolution that you get. So I suggest to you that, in fact, I don't think the odds are even that good. I suggest to you, as you sit here right now and you're determined to go to trial, I think the odds are stacked against you being satisfied with the resolution that you get today. The reason I suggest that is even if you prevail, if, for example, you are the plaintiff and I determine you were entitled to a judgment in this case, I may decide that you were entitled to a judgment to a lot lower degree or a less degree than you feel you are. In practical terms, I may award you a lot less money than you think you're entitled to. In the end, it may be so little money that you really question the wisdom of your decision to come to small claims court to resolve your problem. You'll think to yourself, you know, I can't believe I sat here all morning long, waited 3 months to get here in the first place. This is all I have to show for my efforts.
I like what he's written.
That's not the case if when you leave here at the end of the day, you are satisfied with the resolution that you receive. And that is, of course, because you have beaten the odds and I've decided the case in your favor. And I've awarded you every penny that you asked for. What you leave here with is this, a piece of paper. And that piece of paper will say that you have a judgment and a certain amount of money. And that's it. What I want you to know now is that if that case or the situation you find yourself in, what you've just done is accomplish the easy part of the small claims process.
Got the judgment.
Now comes the more difficult part, turning that piece of paper into something you can put into your bank account. Because I can assure you that you cannot take that piece of paper down to the bank, hand it to them and have them put some numbers in your account, because that certainly won't happen. Now, I suspect that a number of you are sitting here thinking to yourself that, you know, I haven't even thought about what happens if I win. I spent all my time thinking about how I'm going to present my case to the small claims court. I haven't contemplated what happens if, in fact, I prevail and I walk out of here with a judgment. What does that mean? Now, you may know what that means because you may be a veteran of the legal system and have been through this process many times before, and you know what to do to enforce the small claims judgment. That's fine. You can go on about taking the steps necessary to enforce that. I suspect for most of you, that's not the case. This is probably your first, and most likely your hope is that it's your only time in a courtroom and you don't have a clue for what you're supposed to do with that piece of paper. Short of taking it to the bank, your next thought is going to be to ask me or ask the clerk, what am I supposed to do now? It's a reasonable question for you to ask. The answer is going to be, sorry, can't help you. We're the court. We're not your legal advocate in this case. So we're not trying to be difficult, but we have the obligation not to provide you with legal advice. So what do you do if you need legal advice? You go to an attorney. Lots of attorneys around, happy to talk to you about the case.
For a fee.
They'll also be happy to charge you for talking to you about the case.
Yes, this is true.
I would suggest that in many cases, if that's the approach you take, you will end up paying more money in attorney's fees for that advice than you will ever recover on the judgment. So that may not seem financially like such a wise decision to take. Where does that leave you? Well, it leaves you with trying to do it yourself. That's fine. You can certainly do that. You go across the courtyard to the county law library, which is in the Superior Court building. Pull out the book the legislature has written on enforcing judgments and see if you can puzzle your way through that. Or you go home, get on your computer, and do the same thing. That's up to you. This I can tell you. Our statistics show you are much more likely to recover on the resolution to the problem in front of you here today if you achieve that resolution through a negotiated solution,
to each other,
rather than walking out of here at the end of the day with a piece of paper that says you have a judgment. So if you're truly interested in trying to recover something, have something to show for your efforts, you're going to make a good faith attempt today to solve your case without going to trial. As I said, we have 9 cases that are set for trial today, and we have until noontime to resolve them. What happens if we don't get to your case is that your case will be rescheduled. Not for next Thursday necessarily. Obviously, that's or not next Friday. It's the day after Christmas, and the court will be closed on that day. You will come back to court, go through this process again. You will need to remain with us today until your case is called. If you choose not to spend the day with us, when I call your case and you are the defendant, then I will award a judgment, a default judgment to the plaintiff. If you're the plaintiff and you aren't here, then I will dismiss the case. The only exception to this policy is if you settle the case. If you do that, all you need to do is notify us through the dispute resolution folks, and then you'll be free to leave. All right.
This is hilarious. I love that whole bit.
So we're going to do a couple things this morning to assist you in your efforts to try to negotiate a resolution to the problem that finds you here today.
The mediator just showed up.
Perhaps you and the party on the other side of this case have tried it. Perhaps you said, we know we have a problem. Let's see what we can do to figure it out. You've sat down to talk about it, and you've been unsuccessful in coming up with a resolution, and you've turned to the court as a last resort. I also understand that for some of you, that may not be the case at all. Maybe the two of you have just had a hard time talking with one another for whatever reason. Perhaps this problem has aggravated previously existing tensions. Perhaps it has created its own tensions. But for whatever reason, you both have said, I'm right, you're wrong, dug in your heels and said, see you in court. And here, in fact, we are.
He's talking to everybody who's on the docket
I'm going
today.
to suggest that whatever the history is here, you make a good faith effort today to overcome that history and take advantage of the opportunity we're going to give you today to try to settle your case without going to trial. So we're going to allow at this point the folks from the Dispute Resolution Center to let you know where they are and what they're doing to help you today. Ms. Dubuisson.
Thank you, Judge. Good morning, everyone. I am here with my co-mediators, Denise, Leslie, and Kelly. We are volunteers from the Dispute Resolution Center, We have been appearing, or someone from the DRC has been appearing in court for many years, small claims court. Our role is not to give you legal or financial advice or tell you what we think you should do or what we think the judge should do. Our role is to assist you in communicating with each other in order to try to reach a settlement that works for both of you. Your role in this is to keep an open mind, be flexible enough to listen and listen respectfully to the other party. Think in terms of what you need in order to settle your case. It doesn't have to be money. It can be something else. The judge has indicated he can only give you money, a money judgment. You can agree to something else that works for you.
What are you talking
about? Please be respectful to each other, be willing to share all pertinent information. If you do reach a settlement, we have a form that the court has approved. We will fill that out with your agreement. And once it's signed by everyone, it becomes a legally binding contract between the two of you. As the judge said, you're free to go. You will not need to stick around for trial. We have found, and the court has told us, that if people reach an agreement on their own, as opposed to having the judge impose something on them, the possibility or the likelihood is that the agreement will be carried out. One other thing, mediation is confidential. As you're sitting here in the courtroom or on Zoom, anyone can tune in YouTube and watch the proceedings just like they could walk into court and watch.
No one would do that, though, really.
In the breakout room with the mediator, it is confidential. No one has access to that. No recordings are made. Whatever is said in the room is confidential. So with that, Leslie, do you or Kelly or Denise have anything I forgot? Okay. Your mediator will be more specific about how she wants to handle your case, but I think that'll do for the overall view anyway, Judge. Thank you.
Thank you. So folks, I urge you to take advantage of the opportunity that is being offered to you by the folks from the Dispute Resolution Center.
And with that, we have 20 minutes left to hear a case.
Negotiation, and they're here to help you reach a resolution. What we'll do is those folks who wish to consult with one of the mediators will arrange for you to contact them in a breakout room. As indicated, that will be confidential. After you've had that opportunity to discuss the case, if you do not reach a resolution, you'll come back here and we'll have the trial in your case. If you do reach a resolution, then we will have you fill out the document, submit that, and then you will be free to leave at that point. All right.
Our mediators there on the bottom. Leslie, Sue, and Denise. Get to work, guys.
So
solve some cases.
Can deal with that, and we have a room available for you folks who are here present in the courtroom and not on Zoom. You wish to take advantage of the mediation opportunity?
They have to attempt mediation.
Pardon me? They have to attempt it. All right. So we're going to have you go with our other clerk here.
They have to attempt mediation
for that mediation session. At least attempt it.
They have to fail at communication for the judge. This is terrible. They paid a fee. They filed the court. They show up. They get chastised for showing up. They get told that it's not going to help them. They get told that they're not going to get any money, and they're probably going to have to pay an attorney that costs more than any money they would get. And they should just talk it out and fix their problems amongst themselves anyway. And they've got this tiny little docket window to hear
10,
all the cases.
Vaughn.
It's like trying to cancel your internet. You have to speak to 3 different people and get lucky. Not like that, but like,
yes, sir. With us. Hang on a second.
The interpreter. It's like my throat is parched. Just gave a whole TED talk without a break. Now we know why they're so spicy when they actually get to court.
Right. This is number 10
They've
on the
been forced
calendar.
to fight.
Justin Vaughn, Vaughan versus Thurston County Transmission, Inc.
They're not
Case
there.
number
You win.
39359. Mr. Vaughn is present. No one is here on behalf of Thurston County Transmission. Looks like service was made in this matter on October 27th, 2025 by serving the Washington Secretary of State's office after attempts to personally serve at residence and business of Thurston County Transmission was ineffectual.
So can you give at
So
least
no
a
one
Yelp
is here
review?
today. Mr. Vaughn, I believe your claim is for $8,153.73. Is that correct?
But yes, sir. Total your car?
All right. Based on the failure of Thurston County Transmission, Inc. to appear, I will grant you a default judgment in that amount.
Vaughn's like, see, it worked for me. No lawyer, no mediation, easy win. But you also have no money. You have a paper that says $8,000 on it. It's not the same as $8,000. If the court can't even get them to show up to court, then how do you think you're going to get them to pay? Mr. Vaughn, you're setting unreasonable expectations for everybody who comes after you, though.
And Mr. Vaughn, you paid a $50 filing fee as well, is that correct?
Yes, sir.
What about the service fee?
$35.
I think it was about $260 to have for the service company to do all their business, Your Honor.
200? The translator is translating everybody's court for this guy. I thought it'd be like $35 for a service. Usually you just you're renting a off-duty officer for an hour or something, $35.
All right, Mr. Vaughn, I'm entering a judgment today, principal amount of $8,153.73, $50 filing fee and a $250 service fee for a total of $8,453.73. Any questions, Mr. Vaughn?
No, sir. Thank you very much. I appreciate it.
All right, you'll be able to get a copy of that judgment next week.
Winner, winner, chicken dinner.
Thank you, sir.
Check the clerk's office.
Okay,
All right,
thank you.
Thank you for being here. Let's see, who else was not here?
Number 7, the interpreter case.
All right. Number 7. This is Abdul Azimi and Abdullah Arazi, A-R-A-S-I, case number 39356.
That's through the translator.
Mr. Azimi is present, and we do have an interpreter who has been interpreting for Mr. Azimi this morning.
از گفتن که این مورد 3936 برای آقای عظیمی و عرسی و آقای عظیمی اینجا هستن، مترجمم براشون دارن ترجمه میکنن. Yes.
No one has appeared on behalf of Mr. Arazi, A-R-A-S-I.
از طرف آقای آراسی هیچ کسی اینجا نیومدن.
At this point, this case was set for 8:30. It is now 9:43 a.m. and Mr. Arazi has not appeared or anyone on his behalf.
Judgment for the plaintiff.
I am entering a default judgment in favor of Mr. Azimi. It appears that service was made on November 3, 2025 in this case. Mr. Azimi, I'm asking you what your claim for damages
How much would you
are
like?
at this point. Not for the auto, I understand that, but for lost wages, lost earnings.
تقریبا 2-3 هفته به خاطر از اینکه من سه استیتمنت به موتر جستجو کردم گرفتم دیگه به خاطر همین کار توی گپا 2-3 هفته کار از دست داد.
So I wasn't able to work for 2-3 weeks because I was investigating and trying to put together all the claim.
I couldn't work because I was preparing my court case.
What I'm trying to determine is what amount of wages Mr. Azimi lost by not being able to work.
$6,000.
So I asked for $6,000.
Is that for lost wages only?
صدمه که بر موتر وارد شده تقریبا ما 3 استیتمنت گرفتیم که 2 دانش تقریبا $5,000 میشه که 4,900 چند دلار میشه استیمیتش همونجا است.
Okay, so I got an estimate for the damages for the car. I have 3 statements from different places, which comes to roughly around 4,900 something.
I've seen that. I have that. What I'm interested in is whether he can establish how much earnings he lost because he wasn't able to work for a period of time. For a period of time.
Hold, please. Trying to catch another court. Maybe save it for later.
میشکدیم که تقریبا هر هفته ما در اوبر لیفت 13 ساعت 15 ساعت 14 ساعت کار میکنم تا 1000 12 ساعت 13 ساعت هر هفته فرق میکنه ولیکن 1000 12 ساعت 13 ساعت 14 ساعت کار میکنم هر هفته.
اجازه بده. So I work for Uber and Lyft, and week to week it's different. Sometimes it's 500, sometimes 700, up to 1,000 can you lose weekly.
یک هفته 12 ساعت 13 ساعت یک هفته.
So for a week I can work up to 12 to 13 hours.
100.
$1,200, $1,300 a week.
All right. All right, for the damage to the auto, I will award the amount of $4,903.44. That is the middle range of the three estimates that were provided. I reviewed the earnings statement from, I don't recall whether it was Uber or Lyft, that showed earnings for the period of April 2025 through September 2025. And what I see is that between April and June, Mr. Azimi earned about $1,300 a month, a total of $3,900 for the 3-month period. For the 3-month period from July through September, the earnings showed $4,500, about $1,500 a month. So it appears that despite the fact he may not have had his vehicle available to him during that period of time, his earnings did not suffer as a result of that. So I'm not going to award any lost earnings judgment in this case. Mr. Azimi, did you have a service fee cost to have this document served on Mr. Arazi?
مرا یک کسی هست همکاری میکنه از چرچ هست به نام کریستینا کریس همیشه می اوراق ماست.
Okay, so I have it in my documents. There's a lady by the name of Christina that is helping me out through the church I go to.
I'm not sure if you
And
understood
did
the question.
she charge you anything to make the service by mail in this case?
Because if she did, she was ripping you off.
No, I don't have to pay her back. She's paid some fees, but I don't have to pay her back.
All right, thank you.
She was just helping out. Okay, this has been fun. I like the spiel at the beginning, but the judge is just
All right,
too
Mr. Azimi,
slow.
based on what you've told me today and what I've reviewed in the file, I am entering a judgment in the amount of $4,903.44, a $50 filing fee, for a total judgment in the amount of $4,953.44. Any questions, Mr. Azimi?
No, thank you very much.
All right, I've signed that document.
پس من
We'll conclude your case today, Mr. Azimi. And Madam Interpreter, thank you for your assistance today. We appreciate it.
Thank you, Your Honor, and thank you, Your Honor.
Thank you.
You're welcome. Thank you.
Good day.
Good day.
Good day. It's like Paul Harvey. How did mediation go, folks? First up, how was mediation?
I'm looking at number 3. We have nobody on that one.
That's correct. Nobody appeared on this case.
Dismiss.
All right, number 3 on the calendar, the Rance Group versus Rebecca Freese, F-R-E-S-E, and Sean Braley, B-R-A-I-L-E-Y. It's case number 39208. Called or set for on the calendar for 8:30. It is now 9:54 a.m. Nobody here for either party in this case. This case will be dismissed. Claim is dismissed because neither party is present today.
Guess mediation is failing all over the place. Sue, she's back. Her people didn't sort it out. Courtroom breakout. They're leaving.
Number 11 as well. I think everybody showed on that one.
That's correct.
All right, number 11 on the calendar. Andy Furler, F-U-R-L-E-R, versus Sarah Harrington. Case number 39361. No one appeared for the plaintiff or for the defendant in that case.
Court dates are hard to remember, Your Honor.
I have a question about service there, but since no one is here, again, on the calendar for 8:30 this morning, it is now 9:55 a.m. That case will be dismissed based on the failure of either party to attend today.
Can you imagine filing a case and then not showing up as the plaintiff, but the defendant shows up and wins? I guess it doesn't do anything, but maybe they countersue.
Thank you.
Cases ready for trial. Bills will work.
We're on the calendar. Carrie Peterson versus Expedia Group. It's case number 39344. Mr. Peterson is present today. I believe there's no one present on behalf of Expedia. Is that correct? We have anybody here from Expedia?
Who's Expedia Group? Quick Google search. So talking about the
Peterson.
last minute deals, the trips and everything, travel website.
In the brief review I was able to do of the file, Mr. Peterson, I saw that Expedia has requested a continuance in this matter. And I know that you filed a written response in relation to that. Can you give us a brief summary of that written statement that you provided?
Yes, Your Honor. If you're referring to the answer motion for objection to the request, the grounds of that objection were based on the court rules and the Washington State rule that I researched. For starters, it came from a senior paralegal, Ms. Seibel Brew, and I believe in the court's electronic brochure, it clearly says that attorneys and paralegals can't participate in the trial. But secondly, the request for the continuance didn't have grounds for sufficient reason on why they wanted the continuance, and thirdly, it was sent in just the form of an email. It wasn't a formal motion written out pursuant to the court rules or Washington State law. That's all, Your Honor. Your Honor, one more.
Go ahead.
I apologize. Striking the last closing remark, that I wanted to add for the record that arbitration and mediation was pursued in the face of this litigation prior to me actually filing a lawsuit. You can see in the record there was a legal demand that was, a week or days before the process server and all that took place. I did the best I could for alternative dispute resolution at a painstaking effort. So, I mean, it was ignored for 3 months. They had 3 months to prepare and resolve this matter without litigation, without you making the decision today pursuant to the Washington State law.
Mr. Peterson, in reviewing this, I looked at your document, and one of the concerns I think you raised as well is waste of court resources and everybody else's time in this case if we were to continue the matter. If I were to make a judgment in this case and award you what you've claimed, originally $10,000.
Whoa, 10 grand.
By default, in this case, you can, I think, reasonably expect that Expedia is going to file an appeal and you're going to be drug into a lot more of a court proceeding further down the road. It seems to me, under the circumstances, that now that you have got someone's attention at Expedia, and I realize this was a difficult process for you, as it often is in cases involving big corporations where you're trying to get their attention and you feel like you're being ignored or pushed off in those cases. I don't see the particular benefit to this court for its purposes or for you, quite frankly, Mr. Peterson, in attempting to justify a judgment in the amount of $10,000 today without some participation by Expedia in relation to this case, anticipating it's only going to be a more difficult problem further down the road, not a easier problem to deal with. As I pointed out in the presentation, best case is you get a piece of paper that says $10,000 and you're chasing Expedia around. That's number one. Number two, at this point, the process for justifying the damage claim that you have in this case, it really needs to be identified. I think you've claimed for potential of having your identity taken,
pain and suffering,
or misused in some way. I don't really see a calculation in there as to how you get to $10,000 as the value in this case. So I think it would be useful for you as well if we were to continue this case, for you to do an additional document to file with the court that would explain your calculation of your damages in this case. Now, having said all of that, is my thought that I am going to continue this. Can we go to where?
January 20th.
March 6th?
March 6th. Oh.
All right, Mr. Peterson, I know this isn't going to make you happy, but our next available court date is March the 6th to handle this case.
That's why they're trying to get everyone
But
to
as
mediate.
I say, I think it would be
The
useful
docket's
for
just too
you
full.
to do the calculation as to what your damages are. And Expedia now has your notice that this case is going on. And on March 6th, if they have not responded, you will get your judgment as long as you are able to prove the damages that you've claimed at that time. Questions, Mr. Peterson?
Yes, Your Honor. With respect to the damages relation to the small claims action, I work for a veteran services organization that deals with transitioning veterans and disabled veterans. We were relying upon Expedia for housing and work travel accommodations for myself and other employees and members of Veterans Recovery Network. So since this case has escalated, there's been retaliation, and we've had to make alternative arrangements for hundreds of veterans and federal contractors that are civilian workers for the Military and Veteran Affairs Department. So that's where the damages, arise. This isn't just the few $1,000s I've spent with private investigators and ABC Legal and getting attorney consultations for Washington state attorneys.
And Mr. Peterson, you understand that we have a limit on the amount of damage that can be awarded in a small claims court. And it sounds like, from what I looked at briefly and what you just indicated here in your testimony, is that this may be a much bigger problem than this. You are, however, entitled to your day in court on this matter here, but in order to award damages in any amount, I need to have some calculation as to what that is. I can't simply reach out and take a $10,000 figure out of the air in relation to this. So, Mr. Peterson, I've heard, I understand what you're saying. I appreciate the seriousness of what you're saying, and that is the reason why I'm saying you need a full-blown hearing in this case, as opposed to trying to get a default judgment and then having it get all fouled up with additional proceedings down the road. All right, Mr. Peterson, make this your last remark. Go ahead.
Well, Your Honor, the damages were respective to your state codes, RCW 19.86.090, respective to the Consumer Protection Act and treble damage. Now that limits, they go up to 25,000. And, if the shoe were on the other foot and I were the defendant and they were seeking a default judgment for $10,000, would you do the same lenience for me? And I'm just a private citizen or a federal contractor. Would you give the same lenience to somebody like me if Expedia was coming after me for 10 grand? Well, if I was even if I was a nihil dissent no-show?
I believe that I would, Mr. Peterson. I think that it's in everyone's best interest to get a full-blown hearing on this matter, as opposed to trying to proceed with a default judgment. You have now gotten their attention. They know there's going to be something here. And if they don't respond to you, there will be a default judgment available to you at that next hearing on March the 6th. So that's what we're going to do today.
Your Honor,
Mr. Peterson, enough. I've seen what you filed. I understand your position.
Talk to the hand.
We are there. I've made my decision in this case. It's going to be continued to March the 6th. Pardon me?
Sir, Your Honor, I'm not sure. I mean, if, March 6th, I work for the government. So, I mean, I'm going to be going overseas for work. I don't even know whether I'm going to be available on that date. Can I get back to the court particular to that particular judgment?
Well,
I mean, tentatively, obviously, for March 6th, but if there's a, possibility for earlier or later date.
March 6th is the date will offer you the same accommodation. If you find out that you're not available on that day, we'll reschedule it if that's necessary. We're not going to dismiss this out from under you because at some point you're not readily available. That's the next available court date. But again, similar to the arguments you've made about Expedia, we're now giving you essentially 3 months to get ready to be here on that time. If your work requires something different, let us know and we'll see what we can do about that. But for now, we're resetting it to March the 6th.
All right. You guys ready for lunch? We haven't really fought. We haven't argued any cases. These are just the small claims cases where nobody showed up yet. Who's that dude who just showed up in front of the camera? We have somebody's elbow, like, or is that finger? No, that's his finger. Already ate lunch. Next up, what is it? If it's not exciting, we're out of here, Judge.
Good. All right. All right. We are ready to move on with the cases that apparently were not successful at mediation.
Which would be
so
all
the
of
first
them.
ones that were back is number 2 on the calendar. Donald Shue, S-H-E-U, and Young O-O-H versus Bruce Titus Automotive Group. It's case number 39050.
I need to go in the
All
other
right,
corner.
both parties are here. All right. Mr. Shue, are you ready to proceed?
We are, Your Honor.
All right, go ahead. You're the plaintiff.
All right. If I may we proceed in the order where my spouse, Jung Oh, states kind of her factual recounts of the events where she was present, and then I can follow on with further testimony.
All right, go ahead.
Begin.
I have a little cold, so my voice might give out. So I'd like to apologize in advance. Okay, so we proceed. We went to go buy a car. I work for a company that has a link for Jeep dealership to get a discount, and there's like all this discount and all these deals with the Jeep. And when we went there, they won't. First of all, they didn't honor it, and then we want a specific car, they didn't have it, so they asked us to test drive a car that they feel that is right what we wanted. So we test drove that car, but they didn't have it in stock, so they asked us to get an older car that's in a lot that will go in our price range. So we did, and it's not ideal what we have, but that's what was available during that time. We test drove that car, so we test drove a different car. They wound up selling us a older car.
Why'd you
And
buy
they
the older
asked,
car?
so it started during the day. The whole process took the entire day. And then when it was come nighttime, they're telling us to take the car right now, the older car that was in a lot. So my concern was, it's really dark, it's kind of raining now, so I can't really see the defect. So I suggested, can we come back tomorrow? We don't have to necessarily take it today. We can just come back tomorrow. And they're extremely insistent that we have to take the car that day. So we said, can we just, okay, so since you're so insistent, and once again, we offer them that we're gonna come back tomorrow during the broad daylight that we can see the car, and they they just keep on pushing us to take it that night. So they brought it into the dealership. They chamoised it off. It's still kind of wet. So, you know, just being a trusting nature, we drove it home, which we lived close by back then. We go home and there are all these defects. So when we went back, we talked to the Ben who sold us the car. He referred to Michael, who's I believe he's a general manager or who's in charge of the entire situation, and they said they're gonna take care of it. So after that, we were finding all these defects. So at this point, when we go back, I mean, when we found the defect, Michael's like, okay, bring it back. I think the other gentleman was Jason, like he's in a
Jeremy,
maintenance, or I don't know the title, quote unquote. So when we went back, we're pointing out all the stuff that is wrong with the car. It just, instead of repairing it, they make us jump through hoops, or they ignore us. So we go back and they keep on telling us, even though I can visually see there's all this thing wrong, they said there's something wrong with where I'm looking at it. Even if it's like, there's like, for example, there's a lump, but he's like, no, it's a dent. So for me personally, like every time I go, I get such like, I feel really nervous going back, because every time I go, Jason is extremely hostile or so mean, to the fact that I went to Michael and go, I'm in customer service. I've been flight attendant almost 30 years. I'm like, I would never treat my passengers or anybody this way. Like I actually get nervous, because I don't know if he's trying to intimidate me or he's just trying to be extremely hostile, so I will leave him alone. So long story short, I don't want to go on and on. So every time I go, it's really hostile or really mean. So I talked to Michael, nothing has changed. And then we went to I think Jason has left, and I think Jeremy came. So I was really relieved, like there's somebody else. So I once again, I go to the dealership, and don't forget it's a retail. Sometimes we go because no one will address it. It's a retail, and then they get mad if we show up. Like your customers show up, you have a retail chain, but you get mad and you're just really upset, and that's your complaint. And for example, I went to Jeremy, same thing, on the appointment. I give him my name. Soon as he hears my name, sees me, extremely hostile and disrespectful from my perspective, okay? Maybe he might have not said it that way, but let me tell you, I was really, really disappointed. Once again, talked to Michael about his behavior. He told us to go to a specific collision because he doesn't see the same thing we see. So what is the place? Collisions?
Capital Collision.
Capital Collision. This is the one that they deal with. Has nothing to do with us. We have never even heard of Capital Collision. We go there and we address the issue, and they're like, "Oh yeah, this is like something we can't do. We can repair. You just have to go back to Jeremy." And before we went to Capital Collision, which Jeremy told us to go from the dealership, he took all these pictures of defects. So we go to Capital Collision, and we come back, and he said, "Oh, we're not going to fix anything because you chose to go to another dealership." We don't even have that option. We didn't go to a different dealership. Why did you even delete the photos? I don't understand, because you said we decided to go to dealership. We already specifically told the Jeep dealership that with this specific car, we have to only deal with this specific Jeep dealership. So we weren't sure if it's the company of Jeep that treats customers this way. We wind up buying another Jeep from a different dealership, and they actually is completely, utterly different experience. First of all, they're extremely professional. They don't make you feel like a small person every time you want to address anything, which I have right to because I'm a customer. And I know for them, it might not be a lot of money. For some people, working class, it's a lot of money for us. And I mean, I feel like for them, it's no big deal. It's a big deal for us. So the other dealership, they honor all the discount. It was extremely pleasant. If there's any issue with the Jeep, they address it professionally. And you
All right,
know, to
Ms.
be
O-
honest, they don't want us
Ms.
to
O-
go back and forth to the chief. They hate us showing up, but they never do anything. They keep on saying there's something wrong with you because you're so difficult, so we're not gonna deal with you. I'm like,
Right.
I don't
Ms.
understand.
O,
Okay,
Ms.
sure.
O,
Yeah,
time out.
yes.
Right? I need you to address the issue of the damages. So what you're telling me is there was some damage to the vehicle that you did ultimately buy that Bruce Titus Automotive will not repair. Is that correct?
Correct.
All right.
I can go through the sequence of events and refer to specific documents, Your Honor.
All right,
Just
go
the
ahead.
damages.
Okay. So, you know, I've tried to get organized and practice a little bit as I reference documents. So please interrupt me at any time, Your Honor, for clarification. I propose I'll start with the amount. I had exchanged emails with your staff at the court about a different amount than what we had originally filed, and I can explain that. I can refer to two specific documents that I think really highlight kind of the key points. I can walk through a little bit about the tone and how we arrived and the motivations on
opening statement.
how
Just
we ended up
start
with dealing
already.
with Olympia Jeep and Bruce Tice Auto Group, and then also highlight you know, key differences in the dealership experience, which I think is actually relevant for what has happened since we were told by Jeep that we must address these issues with Olympia Jeep since they had initiated the original warranty repair that was determined to be faulty and needed addressing by their own vendor. So on the amount we're requesting, with our legal fees and the estimates that we were provided by Olympia Jeep and Bruce Tice Auto Group's vendor, Capital Collision, the totals are actually in excess of $11,264.95. And we submitted those documentation. It's in the file, but we are aware that the statutory limit or the limit for small claims is 10,000, and we are understanding that and willing to undergo that threshold. So factually, what I would like to point to in our pages of submission in our plaintiff exhibits is a September 26, 2025 email. It's in the index enumerated as number 5. I believe in the system, it's the PDF of number 8. So this is Rick Conley, who is a manager at Capital Collision. He is, again, they are the vendor that was selected by Olympia Jeep to address the warranty defect that the Jeep dealership accepted. And what they state there is that they had determined what needed to be addressed to correctly repair the item that they attempted to address originally. They had advised both Jeep and the dealership, which they
Is
never
this like
acted
hail
on.
damage?
So it was really in frustration of them not following through, and also a bizarre interaction we had with Jeremy Pullar, where prior to us arranging for dropping off the car for being readdressed by the collision department, we highlighted a new defect where we asked for an opinion, and what Jeremy Pullar, besides being very hostile on that visit, insisted that it was a ding when it was clearly a protrusion. We ran our fingers over the protrusion, demonstrated that it was a protrusion. He kept insisting it's a ding. He directed us to Capital Collision.
It was an Audi,
to
not
have
an
their
Emi.
opinion. They confirmed that it's a protrusion, that they would have to address that, and that would be a warranty item. And they told us that they would address that. Jeremy Pullar subsequently on follow-up told us, or told me in a phone call, that he had deleted all of the pictures. Well, we have documentary evidence in email submitted. Bear with me, sir.
This is why I buy used cars with a lot of character. as is.
August 26, 2022. It's page 60 on the index. It's probably going to be further down.
This
Email
will be
to
the
Michael
only
Titus,
case heard
the title
today.
page at 65. And expressed to Michael Titus, who was the general manager at that time, that at no point did we state that we were going to another dealership. And in fact, we told Jeremy that we could not, that Jeep told us that we would void our warranty if we address this anywhere else. There is a procedural matter that I brought up with your staff in email, since the opposing side had submitted records from Jeep themselves of our interactions with Jeep, where we would have records within their CRM records that they had stated this. And the only evidence we have are emails that we have sent stating that. So we did ask for cooperation from Bruce Titus Auto Group to provide that full record.
You have to subpoena
they
them.
denied that they have access to that. So if there are ever any questions as to whether or not we should be addressing this with Bruce Titus Auto Group or with Jeep, I do want to highlight, Your Honor, Jeep had told us that we must deal with Olympia Jeep and Bruce Titus Auto Group. And, we have no access to those records. And your staff said that there was no mechanism to really compel that. But at no point did we
About
state
subpoena.
we would go to another dealership. It was a bizarre
You have
turn
no
of
idea.
events.
Might be a little
When we
bump
dropped
somewhere.
off the car with the collision, we on our own had to arrange for a rental car. The dealership refused to cooperate with us. The rental agency was very surprised in that they have a group account for any kind of warranty claims that they would just submit that. Jeep independently authorized the rental reimbursement. It was during pandemic. It was going to be far more expensive than $50. And they failed to honor that essentially as well. Only recently, a few months ago, did they send us a check for the $309. I did submit evidence on that as well. Factually, there is a letter, we culminated after the bizarre incident, after not getting our issues addressed. We did retain an attorney trying to get some supervision over this and get attention to have somebody truly address the outstanding items that we have been very consistently addressing. We've always been cooperative. We've always been friendly, despite the characterizations and the opposing side's submissions. Their response from Davies Pearson, factually has a number of issues.
The judge's eyes are open, but he's asleep right now.
In their submission and our submission, we have the letter response from Davies Pearson in, again, pages as in submission. In the file here is title page 19. It's probably going to be more like 20 something in the PDF. Here it is. Title page October 19th, 2022. Page 25 in the PDF, Your Honor. Their
He
page
stops
here,
looking. He
their
just
letters
doesn't care
against
anymore.
26. Some factual issues with their letter is one, in paragraph
mediator
3, they assert that while the original vehicle we ordered that was in transit, we decided against that car. The true fact is we attempted originally several months prior. There's an email I have submitted with Daniel Rayberger, who is on the call today, where we attempted to purchase cars my wife had detailed with the special employee discount pricing, with the special incentives that was advertised by Jeep. They had promised they would honor all that. In the email, we detail how the staff delayed. They then sold the car that was in inventory that we wanted to purchase, proposed to us to order. Why we needed a car at that time was my wife's base of some 20 years in Hong Kong for United Airlines was closing. They were moving her base to Seattle, and she would
This
need
is
to
so not
commute.
relevant.
We ordered the car. They promised that there would be no second sticker. They would honor the employee discount. They would honor any advertised leasing specials. And delay. The car was not going to arrive in time. They told us that they would add a $25,000 second sticker on top of the MSRP. They told us that they would not honor any lease specials and they would not honor the employee discount. At that point, we needed a car before the end of the year. They presented us that they would give us at full MSRP a 3-row SUV. At that point, we were fully committed to needing a car. We drove the car.
You liked it.
Decided we would accept the car, given that they would not add a second sticker. They would do full MSRP. And subsequently, when we went to contract for the car, the salesperson, Ben Wright, proposed that not sell us the car that we had test drove because it was a newer vehicle in the inventory, proposed an older car because it had a lower MSRP because of its shifting. As my wife recounted, we stated that we were fine with taking delivery the next day. They insisted. We inspected the car together. Factually, again, in this letter, on the 4th paragraph, saying that after the sale, we contacted the dealership. This all happened contemporaneously while we were purchasing the vehicle on that same date. Factually, that is incorrect. And page 42 in my submissions will highlight that we were present. We've made the discoveries together. There's many
42
issues
pages
here
of
where
evidence
they say we were not
in a small
timely
claims
in
court.
advising. I would want to highlight they have accepted the original warranty repair, that it was theirs. Their vendor attempted to repair it. Their vendor has stated what needs to be done. Their vendor on the additional items have inspected. In terms of their own submission of their text messages with the Jeep representative, the pictured car in their submission is not a Jeep Grand Cherokee. It's a Jeep Wrangler. And at no point did they ever
finally find out the type
Jeep
of car.
representative inspect the car physically. We've never gotten any documentation from Jeep denying warranty claims. We've only had, conveyances of messages by the dealership in which we have no confidence. And in their own vendor inspected the car, provided the estimate, has confirmed the damages and what needs to be addressed. And in fact, the warranty repairs that they did, again.
Mr. Hsu, please.
Stop talking.
I've granted you here almost 15 minutes to present your case. And we've only gotten from 2021 to 2022. We don't have all day to get where you want to go. What I understand is you're telling me this was not a very enjoyable or pleasant experience in dealing with Bruce Titus Automotive. I get that. What I want to know is the damage that's involved. You've given me a number of $11,264. Is that where we are in this case? That's what you're seeking from Bruce Titus Automotive. Is that correct?
That is the total financial impact to us. We understand there's a $10,000 limit. We have submitted the estimates from Bruce Titus Auto Group's own vendor, Capital Collision. Those are present here in our submissions, starting from page 11, Kylie Friend from Capital Collision. Again, this is their vendor.
Right. I've seen some of those documents. So that's where we are at this point. I think I understand what your side of this is. I want to hear from Bruce Titus,
Jeremy.
Automotive Group at this point.
Not Dan. Dan's going to
Is it
talk.
going to be Mr. Rehberger or Mr. Pillar?
Yes, sir. Okay, so I guess I'm a little confused of what the claim is of the 11,000. My understanding, the concern was there's a dent or ding or protrusion on the hood. If we go back to the timeline we submitted, they purchased the vehicle on 12/11/21. On 12/11/21, Mr. Shu sent an email in notice telling us of some scratches on the vehicle. There was nothing mentioned about the hood on that date. The next day, Mr. Shu comes back to the dealership, points out a couple additional spots where there were scratches. According to our records, there's still no mention of a dent at that time. He comes back on the 13th, so 2 days later, and now mentions the dent on the hood. Our team had a tough time seeing it because the way the light reflects and it isn't very obvious. So we submitted the photos to Stellantis. And I think this is where, to us, the crutch of this case is, as the dealership, we don't provide warranty. That is the manufacturer. And so they have to decide, is this a workmanship issue or quality defect or not? We just administer the process. So we submitted the photos. They did agree to repainting the hood. And so we scheduled an appointment with Capital Collision on January 18th of 2022. And so at the same time, there was a radio update so we did that on 12/17. On 12/21, we had our detail crew buff all the scratches and take care of those things.
They buffed
Candidly,
out.
during that process, we had damaged a piece of the spoiler. We replaced it, and Mr. Shu was okay with the replacement. And so we took care of everything that we could do at our level. It took them 2 weeks to pick up his vehicle because they were waiting for the correct daylight during wintertime to inspect the repairs we had done to the vehicle. So we waited the 2 weeks. They came in.
Wait, the sun's not right. I'll be there in 2 weeks.
According to the statements from our employees, they spent about 45 minutes looking over the vehicle.
45 minutes. Oh my goodness. The
rest of this
dealership paints an
stuff
interesting
is
picture.
Very detailed in our timeline. So I think we fast forward, and I think all this comes back down to the hood. And again, as the dealership, we didn't manufacture the hood. We don't control the manufacturer. So he mentions that we deleted the photos, which yes, we did delete the photos. I think it was a miscommunication because Mr. Shu reached out to me at the end of August and stated that we deleted the photos. And when I talked with our people, they said, we thought they were going to another dealership. Now, I don't understand why Stellantis, Jeep, the brand, had told the Shus they couldn't go to any other dealership because truly the warranty is covered at all dealerships across America. So I don't know if there was a misunderstanding or miscommunication, or if Stellantis was stating, we're not going to do anything about your hood. We don't think this is a workmanship issue. And so if you're going to get any hope, maybe it's the dealer will take care of it just out of the goodness of our heart. So I don't know why Stellantis said that, but
around behind the judge.
The warranty is good at any Jeep dealership. He mentioned the photos of the wrong vehicle. That's not the case. If you look at the photos, it's actually a reflection. They have a very dark colored vehicle, and when you're looking at the chips in the paint that he was concerned about, it's a car next to it that's reflecting. And Mr. Shu, I thought the same thing. They're like, oh, this is a Wrangler, but when I asked, they said, no, that's just the reflection, and you look at it, you can see it. So that's, I think, a unfair portrayal of what's happened. I think that's the crutch of it for us. I mean, truly, at the end of the day, I think Mr. Shu's complaint about the product itself is with the manufacturer, not with the dealership, because we don't control what they built. And their concerns about the customer experience, I am sorry if we did not meet your expectations. I mean, we always want people to feel like they had a good experience and they would want to refer their friends and family to us. But ultimately, I guess it's not a crime if we don't meet those expectations. So.
Look at her face. Jung's like, really?
You agree, Mr. Rehberger, that this matter was referred over to Capital Collision for review of the hood area?
Yes, it was sent to Capital Collision because initially we submitted to Stellantis and they said they'd repaint the hood. So Stellantis paid, Stellantis being Jeep, they paid to have the hood repainted to try to fix what was perceived as a blemish, I'm assuming in the photos. And so that was done. And then Capital Collision did that repair. And then they stated that, well, that's the best we can do with paint. And I think they actually painted it a second time. Mr. Shu would have to confirm that. And, they said eventually, no, the hood would have to be replaced to change that because, as the aluminum heats up, it's going to continue to form back to that shape. So.
And so once you learned that situation from Capital, that the repair that was necessary was going to be a replacement of the hood and blending in the paint from the hood and the other areas of the vehicle in the front. What happened at that point?
We sent it, so it had been declined by Stellantis. They told us, no, we're not replacing the hood. Then we reached back out to our rep in the area, the local rep, and said, hey, can you review this again? They're telling us no. And he came back and said, nope, it's, let me see, I think it's in our thing here. They declined to repair the paint. Okay, yeah, so they said they're not defects in material or workmanship. So they went back to their language in their policies as Stellantis, the manufacturer, and said, nope, it's not a workmanship or manufacturing defect. And that's where we don't control what they decide.
You saw yourself this vehicle?
I have not personally seen it, no.
Oh, okay.
Jeremy is on the call.
You're referring to your records and notes.
Yes. Yeah, all the communications we had.
Jeremy?
So basically, Bruce Titus is throwing up its hands and saying, we have no responsibility for this. Even though we sold you the product, we don't stand behind it. Jeep stands behind it. If Jeep says it's not a problem, we didn't do it, somehow or other, this thing failed, but it's not our problem either. Is that the position of Bruce Titus and Jeep?
Part of the position is they took delivery on 12/11, and I understand that they're saying that they asked not to take delivery. But they emailed us on 12/11, not noticing anything at the hood. On 12/12, they didn't say anything about the hood. On 12/13, now there's a mention of the hood issue. Now, I'm wondering if part of Stellantis's denial is time passed. I mean, we've seen cars get into accidents minutes from leaving a lot after purchase. And so was there outside influence for a potential defect to the hood? Potentially. And so again, they're looking at saying it's not a workmanship issue. We are saying we administer between the manufacturer. If there's a defect in what they do, we perform the warranty on their behalf. But again, we don't control what they approve or don't approve when it comes to these types of issues. We have small control over mechanical things, which is what our service departments do, but not over body shop type items because we don't have a body shop and we can't. They have to approve those things.
Mr. Shu, do you have a response to this?
Oh, yeah.
Yes, Your Honor, page 64 and pages in submission, there's a listing of all the defects we had brought up besides the dent. The dent was accepted as a repair. That was the original repair, was the dent as highlighted in Rick Conley's email. That repair was incomplete because they needed a hood, which they requested. On page 83 in the—
Mr. Shu, what's the date of that acceptance of the dent as a issue?
It was immediate. Michael Titus, the general manager, inspected it. They submitted it, and it was something like 11/13 and 11/14. Because of pandemic, they could not schedule the body shop for several, weeks whenever it was, returned the car. At that point, Bruce Titus Auto Group and Olympia Jeep managed it in the relationship with Capital Collision. They handled it. I picked up, dropped off at the dealership. Subsequently, I noticed paint defects from the repair, and that was what they were addressing. And then at that point, Capital Collision highlighted that the dent was still there and that they needed to replace the dent as per Rick Conley's email.
So that is December of 2021?
Somewhere abouts there, yeah. December 2021, and I think the body shop actually attempted the repair somewhere in January is when they scheduled me finally. And then it was February highlighted that the repair was insufficient and needed to be readdressed. And we did submit full evidence of those communications.
Okay.
It was always the dent. It was not a paint defect.
It was always the dent. Or the protrusion.
The paint defects came from an improper repair.
Can we just hear Jeremy? I don't care what he tells us. Jeremy needs to weigh in.
Your Honor, on the topic of, whose fault is it? Who is it? Again, without access to the CRM from Stellantis, I don't have the record of the representative from Jeep telling me I must address all of these issues with the dealership. All I have is in page 3, Bruce Titus merged page number, (1) is my email to Stellantis, U.S. Customer Care. Hi, Lucas. I tried calling the 866 number on Thursday, received no call back. Olympia Jeep refuses to address the outstanding items, including the dent that remains in the vehicle. Here in the second to last paragraph, Karen, your case manager stated I may not visit another dealer to address the items Olympia Jeep refuses to address.
Mr. Rehberger, anything further on your part?
I think we did address the issues. Again, there was some confusion because my team thought that they were going to another dealership. I don't know why Stellantis would tell Mr. Shu he had to work with us specifically, but
we hope he works with somebody else.
I believe him. I don't know why he would lie about that. So, but we did submit all the things to Stellantis. This wasn't because we didn't do something. We did give Stellantis the opportunity to take correction, and they told us we are not replacing the hood. And I guess one point of clarity, the hood isn't $11,000. So, I know he's claiming he has these damages for $11,000, but the cost of the hood is, I think $800. So again, why Stellantis wouldn't provide a hood, I wish they would have, but they didn't. So that's why we're here.
Mr. Rehberger, do you know if your local representative came and looked at the vehicle?
I do not know if they physically came or not. I know we sent them photos.
I think the dealership's about to lose here.
Your Honor, we submitted an email August 26, 2022, immediately after visiting Jeremy Pular, where we stated it was very bizarre that he claimed that we said we would go to another dealership. And in fact, we said, Jeep tells us we cannot go to any other dealership. So we have submitted evidence of us alerting Olympia Jeep that we never stated to Jeremy Pular. And in fact, he directed us to go to Capital Collision to address the new issues and get their opinion, where he insisted it's a ding. And Capital Collision again confirmed the new defect in the paint that bubbled up after the heat wave was a protrusion. And it was a bizarre interaction.
Your Honor, Jeremy's on here. I don't know if
come on, Jeremy.
You want his statement?
He doesn't.
Okay, so
here we go.
as far as the interaction goes, I have emails from Don that said in June that he would be stopping by the next week, and I told him Tuesday through Friday between 8 and 4 would be the best. I believe Don didn't show up until August, and not in between one of those days. We did take photos for Michael Titus so that he could resubmit to the manufacturer. The hood defect was initially sent to Capital Collision. They did address the paint. Don signed off on the repair order that everything was good at that time, and took the vehicle. As far as any new issues that the vehicle may or may not have had, I only have record of the hood. I was not actually here in November, December, January during the initial. But he only came in for the paint defect on the hood, and we submitted it at that point. Capital Collision does warranty their workmanship as well, and I believe they offered to repaint the hood for him at that time. As far as not being able to go to another dealership, I actually have records that he's had warranty work done at I-5 since then under warranty, so he has been able to get warranty work done at another dealership.
All right, Mr. Fuller, let me ask this question. You've seen the vehicle?
Correct.
And what's your response to the hood situation? Is it a ding? Is it a paint issue? What did you see?
I seen what appeared to be a minor ding. Very hard to see at that. That's why I referred them to Capital Collision. If it was a paint issue, they had repainted the hood, and they do warranty their workmanship for the repair that we'd done for Stellantis. So if they're saying that it needs a hood at that point, the repair that was done initially in January, I'm going to say that that dent wasn't there. I wasn't here in January, but this is appears to be a dent, not a paint defect from what they're saying. So what happened between August and January, your best guess, because I wasn't here in January during the initial.
Your Honor, I do want to distinguish. The hood was a dent, a new paint defect, which we alerted Jeremy in email, and we submitted August 8th, 2022, highlighted a new paint defect on the driver's side rear passenger door. And Capital Collision confirmed, Jeremy, during our visit, my wife was there, kept insisting it was a ding and not a bubble or a protrusion. Capital Collision confirmed on their inspection it's a protrusion, and hence generated a estimate at that time and an updated estimate based on their inspection of the defect.
Now we need a hood and a door.
They advised Olympia Jeep of that per Jeremy's instructions for us to have them inspect that specific door. And we have emails we have submitted very consistently highlighting new issues, other issues. Jeremy's assertion that we've had other warranty work done is a non sequitur, because specifically what Jeep was referring to is the defroster grill, the paint defect, and the dent on the hood. That is what we're saying. They told us we must address those issues with Olympia Jeep. They said that having anybody else interfere would void the warranty. They were not referring to subsequent mechanical warranty defects. We've never made that claim.
All right, got it.
Got it. Stop talking.
You know, as I said in the presentation to everybody in this case,
y'all are gonna lose.
Or in court today, these cases get to be terribly complicated. This is something that's been going on for 4 years or 5 years at this point. Pictures, no pictures, new damage, old damage.
Oh, new damage.
New car, different car, switch cars. Who's responsible? Who isn't responsible? You know, really, really a difficult situation. you know, I'm in the business of practicing law. And I think the only people that are lower on the list of folks that you have confidence in besides lawyers is car salesmen. And quite frankly, this doesn't help that impression as we look at this. Olympia Jeep says, it's not us, it's Stellantis. Stellantis says, not us, we're not fixing anything, everything is fine. Capital Collision says, this hood is bad. Nobody will accept any responsibility for it. You know, whether these purchasers went to another agency or another dealership or not, I'm not sure what that adds to the equation here, to tell you the truth.
Don and Jung are about to win.
I think Olympia, Jeep, Bruce Titus, Stellantis, whomever on that side of the equation owes these folks something for this car. Now, I don't know all that goes into that $11,000 that you're claiming, Mr. Shu. What I want to know about is what's the damage to the hood? What is Capital Collision saying about the hood?
Specifically on the hood, Your Honor, it is in their estimate that they generated September. It is page 12.
Your Honor, can I interject for a second? When we mediated the first time, we offered...
Mr. Rehberger?
Yeah.
Not yet.
Okay, sorry.
I'm listening to Mr. Shu.
Okay.
We offered.
The conclusion, sum total on the hood repair to address it is $3,627.02.
Does that include replacing the hood and then blending in the paint?
Yes, it does, Your Honor.
All right. Mr. Rehberger, go ahead.
Because you're about to pay $3,600.
We talked with Capital Collision when this thing started several months ago. They told us, because it would be a redo of their work, that they would help, they would repaint the hood if they could get a hood. So, I mean, I guess from that standpoint, if we can provide a hood and give it to Capital Collision and they'll do it under warranty, does that solve the problem?
Was this discussed in mediation?
Yes, that's what we offered in the last mediation. And it was declined.
And Mr. Shu, that's not acceptable to you. You want money.
We have other items here, Your Honor, that they refuse to address. We've submitted documentation that we've brought them up and they've refused to submit it. Jason, the prior service advisor, straight out point blank told us that these warranty submissions takes hours of his time and he makes no money on it because he doesn't get paid a commission. They refuse to take care of their work, and Jeep tells us that we have to go through them for these 3 very specific items.
And Your Honor, if I may, it's not just, I'm so sorry. Is that okay if I speak, Your Honor?
Go ahead.
Okay, if I may.
Consuming an enormous amount of time, and there are a lot of folks that are waiting for time today as well.
Okay, it's not just to mention, it's not just the repair, right? How many times do you have to go to your Jeep and physically go there and deal with all this abuse and mental distress? I'm going to be honest with you. That's how mean you guys are to us. So when you're saying, what's the big deal? Just take whatever you can. For me, personally, I can't believe how mean you guys were to me. You guys not nice people.
Well, that's neither here nor there. And that's not something as Ms. O, please.
Yes.
I've heard your unhappiness with the treatment that you received through this. I heard how you feel like you were intimidated and compelled to buy this car. This is even the car that you wanted, some car they got off the back lot, apparently. I don't know where it came from. Yet they want to attribute to you that as soon as you drove it off the lot, maybe this damage occurred, but there really wasn't a damage. It was just ding. It's not a workmanship problem or materials problem, because Stellantis says it is, even though we don't know exactly what Stellantis saw or they didn't see. And all these other issues, I don't get. I really don't. to my mind, I'm not sure why you bought the car in the first place. I think you should have, when they said, no, you got to take it today or else, you should have said, or else.
Yeah, walk away.
But that's neither here nor there. That's 4 years old of
you have all the power as the buyer.
I'm really stumped as to what to do here. You know, I understand what Mr. Rehberger and Mr. Polar are saying about, well, you know, it's Landis's problem, not ours. I really don't like that. I think there's
because you're the point of purchase.
A connection here that shifts all the burden to the purchaser and the old concept of purchaser, buyer beware.
The old concept? No,
but
that's
I
still
still
a thing.
think that it has to be something that is reasonably available for the buyer to be able to protect themselves under the circumstances.
$3,600 done.
Hold on a minute. I want to think about this a little bit.
Okay.
Can I just reschedule it for a presentation of an order?
No, we don't get the resolution.
Do you want me to?
January 16th? Yeah.
Okay. Yes,
No, Judge. We sat through all of that and your spiel at the beginning.
Yeah, we can add it to the 16th.
All right. All right. There's an awful lot here that's been presented in terms of paperwork. Mr. Shuas keeps referring to different parts of his presentation in this, and I need to look at that.
Page 64.
I've heard all the testimony I want to hear in this case, but I'm not prepared today to render a decision on this. I'm going to have this reset for presentation of my response, my decision in this case on the 16th of January.
They're going to have to listen to his opening spiel again.
Time, or do we set that other one? All right. We'll try to do this one first after we do the other parts of this. All right. That's what I'm going to do at this point. I appreciate y'all being here. I'm sorry this has been such a difficult proposition for all of you. Mr. Shu and Ms. O on their part, having to make multiple trips to the agency. I'm sure the agency isn't not happy having to deal with them every time they come in the door. But there was a problem here that should have been addressed.
Melina's making our bed for us.
That apparently wasn't addressed, and now it's thrown into the court's lap to try to resolve it. So I will, but it'll be on January 16th.
Thank you, Your
Honor, I have one question?
No.
I'm a flight attendant, so it's really hard for me to move around my schedule. I am scheduled on the January 16th. Do I have to be physically available, or can I just have my husband take over, or do you want me to?
Mr. Shu is fine being here. I'm sure he can represent the two of you in this case.
Okay, thank you so much.
All right.
Sorry for
Thank you,
getting
Mr.
worked
Shu,
up, Your
Ms.
Honor.
O.
Tried to be organized with the document. But
now
Mr.
she's like, oh,
Mr.
quiet,
Polar,
honey.
thanks for being here.
Quiet.
Thanks, Your Honor.
You're talking too much.
Thank you, Your Honor. Appreciate it.
Oh, man.
Now, folks in the courtroom, I think you were second on the list here. Is this Baker? No? Baker and Schultz? Right. And Ms. Daly? Stephanie Daly still here?
Yes.
All right. This is number 8 on the calendar. Stephanie Daly versus Mary Baker and Matthew Schultz, SCHULTZ. It's case number 39357. Both parties are present today. Apparently unsuccessful in their discussion.
And to think we almost went to lunch. We're going to lunch now. We're doing it. I don't know if we're going to be back. That's the problem.
To resolve this case. So
Simply Nikki, thank you very much. Appreciate it. Red's like, I'm done. I'm done. I also need to change the battery on my goat. He's worse than Spirit Airlines. All remaining hearings for today are canceled and rescheduled for January. Bird says, RA, I'm not happy, but it's not your fault. You could not have known. I didn't. This is live. We can't do anything. Red's out. See you, Red. Thank you very much.
It looks like this
Have a great
comes on
weekend,
today
Red.
as
Appreciate
a Counterclaim?
How can I keep watching? Let me give you a link.
Yes.
This is Thurston County Courts 3, I believe. I think we're in Thurston County Courts 3.
So,
let me find it.
Ms. Daly, did you file a case against these folks previously?
Yes, yes, Judge. Your Honor, what happened was, since January, when this was a previous phone call that my sister made and decided to play fake victim, and my niece's husband
don't get us involved in this.
Claimed that I threatened him with a knife when I never had a knife.
Oh, now it's getting
It turned
good.
into a domestic violence suit. And this happened when I was recovering from breast cancer, and I never threatened to kill him, and I never threatened to kill her. So
let me try to focus here. Did you file a claim against?
Yes, I did. It's over my
Baker and
belongings.
Schultz?
Yes, it's about my belongings. And I had, while I was sorry, Judge.
Ms. Daly, has that case been resolved?
The case is still pending because what happened was she has sold all my belongings when she was told not to by the judge that is handling the case between us. And I had to file the case in all my belongings that she was told not to sell. And she claimed that there is an email.
Hold on, Ms. Daly. Which judge?
Blue Stars.
Which court case are we talking about?
Oh,
The
gee,
small
before you
claims
know it.
case?
This court case is filed by me. The case that she has against me, we are currently in that she refused to resolve.
I'm going to move back to my regular
here
place.
in this small,
I have to watch this.
Not in this court.
Small claims court?
In this Thurston court, yes, but not in this small claims. This one is mine. So if you really think about it, the court case that she filed against me, theirs is the domestic violence. Mine is the small claims, which is mine. She's trying to countersuit mine.
Wait. So my initial question was, did you file a small claims case
against her?
Against Ms. Baker for
my
damages to your property?
Yes.
You did. That case is still pending? Is that what you're saying?
No, the other cases that she has against me is pending.
That's the criminal case?
Correct.
All right.
That's why I'm trying to say there's that going, but this one is the one I filed that we're here for today. She's trying to countersuit that.
I'm guessing mediation didn't work with you either, right?
I'm still confused, Ms. Daly.
I know. It's kind of confusing. I'm trying to figure out myself how that turned out to a countersuit.
Does Ms. Daly have another case pending in this court, a small claims case?
I can take a look.
Yeah, I'm kind of confused myself because the last I checked, I filed this.
Mediation has got to be a pretty depressing job up in Thurston County. I feel bad for the who was it? Young Joe's the car dealership case. They're going to have to come back on the 16th and listen to that whole 30-minute spiel about you're going to lose and you're not going to like it again before they hear if they got anything.
The same parties.
What's Melina doing? I think just regular chores and stuff. Clean up the house.
Right. So another small claims case, but different.
Yeah,
different.
It looks like it's not related to this. This is why it's not.
Different Stephanie Daly.
May I shed some light on the situation?
And you are Mary Baker?
I am Mary Baker.
Go ahead. I don't want all kinds of background. I don't want threats. I don't want civil stuff or criminal stuff.
Correct. So we received notice in our mailbox that she is suing me for property. I am therefore counterclaiming for rent and utilities, non-payment of rent and utilities.
All right, that I get.
Yes.
I don't get, I mean, a counterclaim is filed in a case that's originally filed by the other party. They make a claim and then you file a counterclaim.
Loving it.
Correct.
But we're not finding a case filed by her.
By her? Ms. Daly filed, and we got notification of it right here, if that helps.
Yeah, let's see it.
Okay,
Did you just dismiss it, Judge?
this is what was dropped off by our.
39357. It's this case number.
Yes.
Did she mess up the paperwork? Okay, I have posted in chat the link to.
So why am I confused?
I don't know, Judge. The link to this particular feed that we're on right now.
It's for the property that was in the home. She was told not to touch the property.
I'm gonna go to lunch. I just can't take any more drama today.
It's my belongings that she had sold, that she was told not to touch, Your Honor.
I've abandoned all hope. The mods have bailed already. We need to wrap up. Okay, so we'll do that. We'll wrap it up. It's only 2 o'clock. It is the holiday season, though. There's not a lot else to watch. I don't know if I'm coming back. My son just got back. That's part of the problem. I want to hang out and talk to him and see how he's doing. He slept on the drive all the way home from the airport. So, and Mrs. R.A. is back from Salvation Army. They finished their gift thing. So that's cool. But it's the weekend. It's the weekend. Thank you. I do love this holiday season. We get some funny court cases because we do a lot of court hopping here. Y'all are amazing. Mods are incredible. Thank you very much. I'm sorry that I put you through so much. You're incredible. Thank you. All of you. All of you that make this community just the amazing place it is. I appreciate what you've done. This is a dream come true for me, and you make it possible for me to do what I love to do every day. It's never a boring or I'm never mad that I have to go to work. I love this. I love hanging out with you guys and watching court, and thank you for making that the way it is. Tonight when you go home, please hug the people you love, smile at someone, make their day just a little bit better, and please stay safe till we go live again. Monday morning, we'll be back. I don't know if Thurston Judge is going to be back. This might be his last day. But if you want to watch that one, there's the link in chat one more time. You can jump to it. You guys are amazing. Have yourself a great weekend. Happy holidays, everyone. Be good to each other. We'll see you on Monday. Bye-bye.